Faites l'appel, s'il vous plaît, Monsieur le greffier.
Monsieur le connétable de Saint-Hélier. Madame le connétable de Saint-Laurent.
Présente.
Monsieur le connétable de Saint-Brelade. Monsieur le connétable de la Trinité.
Présent.
Monsieur le connétable de Saint-Pierre. Madame le connétable de Saint-Martin.
Présente.
Monsieur le connétable de Saint-Jean.
Présent.
Monsieur le connétable de Saint-Clément.
Présent.
Monsieur le connétable de Grouville.
Présent.
Monsieur le connétable de Saint-Ouen.
Présent.
Monsieur le connétable de Sainte-Marie.
Présent.
Monsieur le connétable de Saint-Sauveur.
Présent.
Monsieur le député Southern. Madame le député Labby.
Présente.
Monsieur le député Tadier. Monsieur le député Luce. Madame le député Dublé. Monsieur le député Morel. Madame le député de Hegera. Monsieur le député Ayer. Monsieur le député Ward.
Présent.
Madame le député Alves. Madame le député Gardner. Monsieur le député Gorst.
Présent.
Monsieur le député Farnham.
Présent.
Madame le député Moore.
Présente.
Monsieur le député Mezek.
Présent.
Monsieur le député Joseph. Monsieur le député Balash. Monsieur le député Coles. Madame le député Poré. Monsieur le député Ward.
Présent.
Madame le député Miles.
Présente.
Madame le député Scott.
Présent.
Monsieur le député Renouf.
Présent.
Madame le député Curtis. Madame le député Feltham.
Présente.
Madame le député Binet. Madame le député Jeune.
Présente.
Madame le député Miller.
Présente.
Madame le député Howe.
Présente.
Monsieur le député Binet. Monsieur le député Ferry.
Présent.
Madame le député Kovac. Monsieur le député Curtis.
Présent.
Madame le député Ward.
Présent.
Madame le député Wilson.
Présente.
Madame le député Stevenson.
Présente.
Monsieur le député Andrews.
Monsieur le doyen.
Notre aide soit au nom de Dieu qui a fait le ciel et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et les puissances de la terre, pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir que les affections de tous ceux qui la composent, de les conduire tellement toi-même par ton Saint-Esprit, que toute leur délibération est accompagnée de ta bénédiction. Réussis au bien et au soulagement du peuple qu'il te plut de commettre à leurs soins. Car nous t'en prions, au nom et par le mérite de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite sur la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonnons nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie point en tentation, mais délivre-nous du mal. Car à toi est le règne, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le connétable de Saint-Hélier. Monsieur le connétable de Saint-Brelade.
Sir, the Constable of St Bernard is away on state's business.
You know the nature of the business that he's on?
He's on a APF in
I was content that the constable
Georgia.
walked away on state's business. Yes, thank you very much. Away on state's business.
Monsieur le connétable de Saint-Pierre.
Présent.
Monsieur le député Southern.
Présent.
Monsieur le député Tadier.
Sir, the deputy is away with the APF as well.
I was content to be marked away on state's business. Yes, away on state's business.
Monsieur le député Morel.
Présent.
Madame la Deputy Alves.
Présente.
Madame la Deputy Gardner.
Malade.
Vous jurez que Madame la Deputy Gardner est tellement indisposée qu'elle ne peut pas assister aux États sans exposer sa santé. Monsieur le Deputy Joseph. Vous jurez que Monsieur le Deputy Joseph est tellement indisposé qu'il ne peut pas assister aux États sans exposer sa santé. Monsieur le Deputy Balash. Madame la Deputy Kovac.
Sir, Deputy Kovac is presently away with her daughter who qualified for the Dance World Cup. She distributed an email yesterday and she's requesting that the Assembly mark her as excuse, if the Assembly feels fit to do so.
Are members content to mark deputy excuse? Excuse. Les États sont constitués. We now return to the debate on the removal of compulsory independent taxation. The members listed to speak, come to you, Deputy Miller, are Deputy Balash and Deputy Howell at the moment. Yes, Deputy Miller.
Thank you, sir. I would just like to ask a question. I'm not sure it's for you or the AG. I'm sorry for the late question. About the actual wording of the proposition, because I do think it's somewhat ambiguous. As we discussed yesterday, following Deputy Farnham's speech, the proposition uses the term a joint tax return in paragraph A, and it then refers to joint taxation in paragraph B and indeed paragraph C. As the Minister mentioned yesterday, we don't have joint taxation. Joint taxation is not a term of art in Jersey law. What we have is married man's taxation, where, to emphasise the point, the wife's income is treated as that of the husband, and the husband makes his tax return, which includes the wife's income. So how does this proposition then stand? Because the Treasury Minister, a certain Treasury Minister, could take a very literal view of this and say, well, we don't have this, therefore I can ignore it, it's ineffective. Or do we... I mean, the reference to joint tax suggests either a continuing misunderstanding about the nature of our tax system, or because joint tax is a more palatable way of describing it than married man's taxation. But what we are talking about is married man's taxation. There's nothing joint about it. So what do we do with this? Do we assume that joint tax is referring to married man's taxation? How does the Treasurer deal with this going forward? Thank you, sir.
Well, the proposition has... Would you want to respond to that briefly? The proposition is in order, and it's been ruled in order, so the Assembly is entitled to debate it, and it is debating it. It's really for the proposer to say what he means, and if it's not clear, then he'll make it clear in his closing remarks.
Sir, may I
Yes.
ask a question of the Attorney General, sir? Because this phrase, married man's taxation, is being... let's call it weaponised for this debate. So where in the income tax law, may I ask the Attorney General, does the phrase married man's taxation or married man's anything appear? Thank you.
Well, the Attorney, you're going to now deal, aren't you, with the questions that you were left with yesterday. Is that right? Before we resume with the debate. Before you do, Deputy Barbara Ward.
No, it's to put my name down for
To speak.
speak.
Thank you
if
very
I may,
much.
sir.
That's
Thank
noted. Yes.
Sir, if I might deal with Deputy Farnham's question first.
Yes.
So as I thought I made clear in my answers yesterday, the term joint taxation does not exist, it's not used in the income tax Jersey law of 1961. Article 121 of the income tax law provides for effectively, when read in conjunction with the definition of spouse A and spouse B in the income tax law, it provides that the income of a wife is presumed to be or treated as the income of the husband for the purposes of income tax assessment. So the concept of joint taxation is not one that exists in the 1961 law. If I might turn to Deputy Balash's question or revised question to me that he put last night. Sir, Deputy Balash's question asked me to reflect on the draft legislation that has been lodged in relation to stage 2 of independent taxation, which is due to be debated by the Assembly at the next sitting. And he specifically asked me to look at Schedule 7 of the draft law and consider whether that form that is set out in Schedule 7 would solve any difficulties as regards the reservations that have been lodged by Jersey in relation to the CEDAW Convention. But so looking at Schedule 7, that provides a transitional provision in relation to the year tax year 2024. It's one that's not intended to be permanent. So the way the draft legislation works is that it makes independent taxation compulsory for the years 2025 onwards. But Schedule 7 provides for an ability for cohabitees or civil partnership or married couples to opt for independent taxation early in the year of 2024, and also to opt for that unilaterally. So either spouse or either civil partner can opt to do that for 2024 independently of each other. It doesn't have to be a joint decision. So in terms of how that corresponds with CEDAW, in my view, that Schedule 7 itself does not create any issues as regards CEDAW because it's only transitional in nature, and it also is providing more fundamentally the ability to opt for independent taxation earlier on. So that's my answer.
So can I just
Yes,
ask for
Deputy
some clarification from the AG? He mentioned cohabitees in his answer. Did he just mean married? Was that a slip or?
That was a slip. It was meant to be married couples or civil partners.
Thank you.
Yes, Deputy Scott.
So just with respect to Schedule 7, the paragraph 3 has a paragraph saying partners to be taxed jointly. Will the Attorney General just confirm that's perhaps a bit misleading in the context of this conversation because, or a discussion because, thank you.
Yes, it is. The use of that language is perhaps somewhat misleading because it's essentially saying that unless someone opts for independent taxation, then they are treated as carrying on with the current regime of the spouse's income to be treated as her husband's income, or the female civil partner to be her income to be treated as the income of the male civil partner. So it is, that language is somewhat misleading.
Just to follow up, that's not just confined to the female, or you could be talking about two men or two women, depending on the nature of the relationship, I understand. Is that right?
I would need to check that.
Yes, Deputy Balash.
So the debate yesterday seemed to me to show a gender division in the Assembly, which is unusual and indeed rather sad. May I make it crystal clear, therefore, that I do not wish to turn the clock back to 1928, nor do I subscribe to the view that married women should be under the control of their husbands, nor do I seek to facilitate the economic abuse of women. I don't believe, in fact, that any member of the Assembly wishes for any of those things. And with great respect to them, I think that the passionate speeches of Deputy Miller and Deputy Miles were off-beam. That is not what Deputy Farnham is seeking to achieve. One might feel strongly that independent taxation should be compulsory, but that does not mean that those holding a different view are trying to perpetuate the subjugation of women. No one, but no one, is seeking to compel married women to accept that one of them, or married people rather, that one of them has primacy over the other. Indeed, it's the complete antithesis of that. Deputy Farnham is pro-choice. He is in favour of giving men and women the right to continue to choose to file a joint return if that is what they wish to do. But they must both want it. It will not be possible for a husband to decide that issue for his wife. All that is sought is to preserve, for those who want it, the right that they have exercised, sometimes for decades, to file a joint return of income for tax purposes. I, sir, declare an interest in that my wife and I are among those people. When we married nearly 40 years ago, my wife told me, I don't want anything more to do with tax. You deal with it. And so I have for 39 years. Why does that have to change? It is due to change because the government says, we know what is best for you. Everyone must file an independent return, whether they like it or not. If independent taxation becomes compulsory, I shall in fact have to fill in 2 tax returns and not 1. I shall have to go through the process with my wife's forced cooperation of getting her a Yoti identity. And remembering how long it took me to get through that labyrinthine process some years ago, that alone is not a happy prospect. And the tax department will have 2 tax returns to deal with, and not 1 to administer. I struggle to see how that is more efficient, bearing in mind the thousands of people involved. I think this is essentially a generational issue, and I have no objection, the Treasury Minister will be pleased to hear, to joint returns being gradually phased out. My children would not dream of not filing independent tax returns, but thousands of older couples don't all see it that way. They don't want to change the habits of a lifetime. I don't know what the figures are, but there are certainly a substantial number of them, and they are probably those who take the trouble to vote. What I find so frustrating about this debate is that the object is not difficult to achieve. The draft income tax amendment stage 2 of independent taxation law lodged by the Treasury Minister on the 6th of June makes that absolutely clear. The new Schedule 7 applies to those who have elected not to be independently taxed for the 2024 year of assessment. It sets out clearly how it can work in tandem with a system of independent taxation. Now, that could easily be extended to the year of assessment 2025, and indeed 2026, and so on. A light stroke of the pen by way of amendment to Schedule 7 could achieve that end. The Minister's draft law would not have to be torn up with a fresh start if Deputy Farnham's proposition is adopted. The Minister's comment suggests that this would cause immense complications, but I am afraid that that is special pleading. It obviously is not complicated because the Minister's own draft law makes provision for two systems to operate in tandem. Indeed, the comments of the Treasury Minister contain a number of tendentious statements. It is claimed that the policy for compulsory independent taxation has been developed over several years in response to islanders' preferences. I don't recall ever being asked whether I wanted to be compelled to file an independent tax return, and my wife too. It is easy to frame questions to get the result that you want. I'm sure that most islanders want independent taxation to be readily available, but that is an entirely different issue. The report of the Treasury Minister in Projet 41 states this in the introduction. Until recently, a married woman's income was always treated as her husband's income. The filing of the annual tax return was the husband's duty. The tax liability was in the husband's name only, and a married woman, when trying to access tax information, would be denied that access unless her husband provided express permission. These anachronisms will be confined to history if states members vote to introduce mandatory independent taxation. That is, I'm afraid, a misleading statement because the anachronisms have already been confined to history. It is not related to mandatory independent taxation. When a system of independent taxation is introduced, although not mandatory, the discriminations will have gone. Any person can choose to be independently taxed if he or she wishes. No married woman or partner B in a same-sex relationship will be denied access to their own tax information. The anachronisms will already, indeed have been now, to a certain extent, confined to history. The great social leap forward has already happened, and quite rightly too. What this is about, sir, is denying the right of some married couples who have filed joint returns in the past to continue to do so. As I have said, I am sympathetic to the notion that the dual system should not last forever. Deputy Farnham's proposition achieves that. If the Minister really wants a tax regime which does not permit married couples to file, in effect, a joint return, why doesn't he offer some inducements to such taxpayers to change to independent taxation? Offer some allowances which are only available to those who file independently. Get his talented officials to use their imagination. Isn't that a better way of proceeding than the nanny knows best approach, where people are compelled to do what they don't want to do? Thousands of taxpayers don't want to change from a system that is convenient, easy to understand, and familiar. They should not be forced to do so. I'm going to vote with Deputy Farnham.
Thank you. Deputy Howe.
Thank you, sir. Good morning. Yesterday, we heard some impassioned speeches, including those from Deputy Elaine Miller, Helen Miles, and Deputy Hilary Jearn. I understand their arguments. I too am a proponent for women's rights, and I too would never want a woman to be regarded as a chattel of her husband. So for any person who wishes to fill in an independent tax form, then I fully endorse them in being able to do this. It would seem, however, that very few couples have opted in voluntarily. I think I understand why. Most couples have been filing their tax in this way for very many years and are happy with the arrangements. I think it's some 18,000 couples have chosen to stick with the current system. That's 36,000 individuals, almost a third of the number of people living in Jersey. If mandatory independent taxation goes ahead, some of those being asked to submit individual returns will be worse off in the future than they are now. So the Treasury Department has come up with a suggestion of a compensatory allowance for 10 years. But after 8 years, it will need to come back to the States. The trouble is, I am unsure how this will be administered. Presumably, to work this out, the department will seek the permission of both parties and will need to amalgamate the two individual returns to work out the compensation. So who's going to receive the child allowance? You can say it may split it 50-50, but what happens if someone's looking after the child 80% of the time? And how will the amount a student receives to go to university be worked out? I am sorry, sir, but I feel we are heading for another muddle, just as we headed into a real muddle when forcing all islanders to change to current year taxation. I would like to read out an email that all States members received. This is from an islander. I totally object with being informed that from 2025, I will be forced to move to independent taxation. I am a married woman of over 32 years, and I am also the wage earner in our relationship, with my husband now being retired due to ill health. I think that couples who are married or whom are in civil partnerships should be given the right to decide if they wish to have independent taxation. You tried this option before, that people could change to independent taxation if they wished. And you can see that it was not very successful. And I think that speaks volumes, that it is not wanted, not required, and certainly not the right way to go. I think when this debate comes up in the States this week, you need, for once, to listen to the people of Jersey and understand their needs, not what you think is beneficial to your beliefs. Sir, I'm not a fan of making things mandatory. I stand for choice. I was elected to represent the views of islanders in this State's Assembly. Sir, I am listening to the people of Jersey. I shall vote in favour of Deputy Farnham's proposition and hope that enough of us do the same so that islanders can choose how they wish to file their tax. They can elect to pay independently or as they do now. Please support this proposition. Thank you, sir.
Thank you. Deputy Barbara Ward.
Thank you, sir. Deputy Howe seems to have taken my speech, but I have promised people that have contacted me that I would stand up and echo their views, and I think it was my duty, as someone who's been elected, to do so, so that it is on record. So forgive me if I'm actually going to repeat some of the aspects that Deputy Howe has raised today. May I thank the Deputy for bringing this, I think it's a very important proposition, to the Assembly for a debate. As I've just alluded, that I have been contacted by many islanders very concerned about what may be happening in the future, having to be taxed separately from their partners, especially as they've been taxed as married couples for up to 40 plus years. The people concerned think that this new idea is so wrong, dictatorial, and that their right to choose will be eroded and taken away. The evidence demonstrated to date, set out in the proposition, is that we're talking about 19,000 couples who pay taxation, and out of those 19,000, at the time was 2.4% chose to move to independent taxation ahead of any new changes in the taxation legislation. This, I do believe, is an overwhelming evidence that there are 18.5 thousand couples, or should I say 37,000 people, are islanders, are voters, out of a population of 105,000 have spoken and exercised their right to choose, indicating that they do not wish to be compulsory taxed independently. So 37,000 is about a third of our adult population. That is a lot of people. We as an Assembly were elected to listen to the electorate, be open and transparent, and I feel I cannot ignore those 18,000 plus couples or 37,000 individuals, people on this. I also believe that we should protect the people's fundamental right to choice, especially if this has been in practice, well, for the past 100 years and has worked well. If we ignore the right to choose, in 2025, this right will be removed and applied, what I believe is retrospectively, affecting many thousands of people. I also feel that it seems to me that we are being forced to fit around computer systems. And in this day and age, it should be the other way around, and that the IT systems should actually be able to facilitate what we want. The Deputy and I may have differed in the past on certain topics, but today I must say that I'm totally in agreement and will be supporting the Deputy's proposition. Thank you everybody for listening. Thank you, sir.
Thank you. The Connétable St Martin.
Thank you, sir. I cannot in good conscience support Deputy Farnham's proposition. I was a member of the previous Treasury Minister's review panel into women having the right to file their own taxes. We fought for the right for women not to be subservient to their husband, not to be known in the law as chattels. We're in 2023, not the dark ages. The UK law changed in 1990. People in the UK have managed with the change. The previous government tackled this and was well supported. Deputy Farnham was Deputy Chief Minister at the time, and I believe he voted for it. I'm proud to say that I was also responsible for the funding into the work to be carried out into violence against women. So how can I, in good conscience, vote for this? Sadly, there is a high percentage of economic abuse in Jersey. There are, of course, many, many wonderful marriages and partnerships with no hint of coercion or abuse, but these are not the ones that we are concerned about. I've been told by fellow members that we have to think of old married couples. Well, yes, but we cannot not move forward because of this section of society, a section I realised yesterday that I'm a member of. I've been married for 37 years, which is nearing 40, and I and my contemporaries do not consider ourselves old or incapable, and nor do most people. We have the most wonderful women in the parish, many of whom are widowed and that, who are, my favourite one is nearly 90. Women are very strong. We are not what is being portrayed in the States Assembly at the moment. The majority of women earn now. My pay should not be an extension of my husband's pay, and nor should any other women's salary. It is a misnomer that we have joint taxation. Sorry, it is a misnomer that we have joint taxation. This is a married man's taxation. The wife's income is treated as her husband's income. Deputy Balash says that thousands of people do not want to change, but thousands of people actually do want to change. And should we not take these people into account? Joint taxation is not mentioned in the 1961 taxation law. Voting for this leaves women as subservient to men, and I cannot tolerate this. Before you vote on this, please think if you're for equality, equity and fairness, if you really, really are. And if you are, please reject this proposition, because voting for this proposition is just paying lip service to equality. Thank you.
Thank you. Does any other member wish to speak? Deputy Mezek.
Thank you, sir. I was very grateful yesterday to the Home Affairs Minister for drawing to attention the Assembly an article in the New York Times where I'm quoted. I didn't realise I had reached such lofty heights. And as she recited the quotes in there, I couldn't help but think that I couldn't have put it better myself. I said back then that Jersey's tax system, and in particular the, I would say, pernicious and out-of-date and medieval element of our tax code, which treats the income of women, of married women, as that of their husbands, is totally unjustifiable, does not fit into the modern age, goes against all those principles of equality, and I stand by that 100%, and I look forward to the day where we can say goodbye to that element of discrimination in our tax code. I stand by that wholeheartedly, and my voting record in this Assembly is clear on that, where I voted in favour of the transitionary arrangements in 2019, where some who are now in government abstained, and I voted in favour of the stage 1 part of independent taxation, where some who are now in government voted against. And I'm perfectly happy to say that. Independent taxation makes perfect sense on so many other levels as well. It makes sense on a practical basis for administering a system. It makes sense on the basis of fairness and equity for everybody to go through that system on the same basis. And I, sir, want to see an income tax system which is based on those principles of fairness, a progressive tax system and equity. I must say, I do enjoy the irony of hearing others make that same case as me, having in the past voted against simplifying our tax system by abolishing the 20 means 20 calculation and putting everyone on marginal relief. I enjoy the irony of that debate taking place immediately after we've had a debate on the high net worth tax arrangement, a separate tax arrangement. All those arguments about bureaucracy count equally valid for that as well, and that is nothing but discrimination. So there's a clear double standard there, sir. And I think having an equal, fair tax system on the basis of independence for everyone makes perfect sense. So this debate is not a question of the principles, it's about the practicals and whether what this Assembly will eventually be asked to adopt actually does what it's meant to do and whether it genuinely serves the interests of islanders. And I have little hesitation at this point in describing what we're going to be asked to support as a fudge, because it doesn't do what it's meant to do. And I'm very happy to say, sir, that when I voted in support of the stage 1 of independent taxation, as did my Reform Jersey colleagues at the time, we put on record very clearly that though we supported that principle wholeheartedly and voted for it at that point, that support would disappear instantly if at the next stage of this process we do not get the safeguards that we require in terms of ensuring that those on low and middle incomes are not unfairly penalised, and that the allowances are put in place in such a way to secure that for these people. And that has not been done in what will be coming forward to this Assembly. So I've seen tax experts out there in our community who've commented on this, who have described the independent taxation that will be put to this Assembly as nothing more than an illusion. And here's why. You will be asked to do 2 separate tax returns. That will be independent, and it will be each member of that relationship's legal duty to do that, not the legal duty of the other person in the couple to do it. One will do their tax return, the other will do their tax return. They'll do that separately, they'll file them separately, and the first thing the tax department will do is they'll get them both and put them together to decide how much tax they owe. That's not independent taxation. And so I would ask the question about the practicals here. If you have a couple who submit their tax returns separately, they receive their tax assessment separately, the tax department uses the formula they've come up with to put their compensatory allowance together and work out how much tax each of them owes, and say that appears to work all fine, and then a few months later, it's discovered that one person in that couple filed an incorrect return, and therefore the compensatory allowance was calculated incorrectly, and somebody had spent months paying for it incorrectly. They could be criminally liable, actually, for not paying the tax that they were meant to, and if they don't fix it, again, could be criminally liable for that, for the mistake of their spouse, not their own mistake. Oh, some independence is that. So there have been allusions to other systems about how they facilitate independent taxation with transferable allowances. I believe Deputy Scott has mentioned this, and she's quite right. There are other systems that can work perfectly well to do that, that provide you with genuine independence and provide couples the choice on how they want to distribute their allowances between themselves and maintain genuine independence that way and freedom of choice through a system of independence. Or you can have the system that instead is proposed with a compensatory allowance with inequities throughout it because of the generational unfairness that will be, depending on when you got married in that process. And the cloud that will be hanging over you over the next 10 years about what will happen to you when that compensatory allowance disappears, or if it does disappear, or if we find a different transitionary arrangement at that point. Prolonged anxiety, prolonged confusion, and for what, when we could have found an option for independent taxation that dealt with that. So, sir, I'm not going to accept any kind of guilt-tripping over this proposition as someone who staunchly believes in the fairness and the practicalities of independent taxation as the best way of having a tax system, and for not having any sympathy whatsoever with views and values that are frankly well out of date about how women's income should be treated in our tax system. And that's why I find it so disappointing that when there is such agreement on that principle, we have the practicals put before us that don't do the business. That's unfair on us, and it's unfair on our society. So, sir, I say to Deputy Farnham in lodging this proposition, which I think in it has a tone which I don't agree with. However, I can still support it on the basis at least of paragraph C, which I'm surprised hasn't been referred to by other members who've spoken against this proposition, given that it very clearly asks that there is steps to modernise those taxation returns, that gives the government a mandate to at least start removing some of those elements of discrimination that still exist within our tax code. But in the meantime, at least, maintain the choice for married couples and civil partners to continue with, and I know there's semantics about this, but for a return that covers both people's income in that return. And I would like to see it revisited very soon in the near future where we can come up with a version of independent taxation that does what it's meant to do, provides equity across the system, and is not based on the fudge that is before us, which is not true independent taxation because of the liabilities that will still remain for the other, in what in most cases will be the wife or partner B or whatever they're called in the tax code, that will still remain there, that they will still be at risk of punishment if things go wrong, and which determines how much tax they pay in the first place. That is not real independent taxation. And we still have that door open for people being made worse off in the future if that compensatory allowance is not dealt with. There are other ways to do it. It's disappointing that that's not what the Assembly is being asked to decide. And so I reluctantly vote in support of this proposition to give us some breathing space to get it right so we can have proper independent taxation and not the fudge that has been put before us.
Thank you. Before calling on the next speaker, can I draw members' attention to the fact that in the public gallery accompanying the Deputy Bailiff, His Excellency Bruno van der Pluim, the Belgian ambassador who is visiting the island at present, and can I ask members to welcome him in the customary fashion? Thank you. Deputy Stevenson.
Thank you. I don't propose to go over the speeches of those who I absolutely agree with, the likes of Deputies Miller and others who made some extremely good points yesterday, Deputy Miles and Jearn, and then Conatable of St Martin this morning. Those points are extremely well made, and just put on record that I absolutely agree with them. I just want to pick on a few points that I think certainly I would like to be added to this debate. The first is, in his opening, Deputy Farnham referred to the low uptake of those voluntarily moving as evidence that people don't want this move. And I think that's just absolutely not true. That's not how these things work. I'm one of those individuals who has not opted to move to it. It does not mean I do not agree with it. It actually reflects more, I would say, human nature and people's busy lives. And actually, I would say that it's not fair to claim and put words in those people's mouths that means they do not support it. What I would also add on a similar note is that this move was very widely consulted on over 4 years, and I think we're forgetting that point here. It's very easy to take the emails that States members are sent in the weeks running up to a debate as evidence that everybody feels that way. And of course, those views are hugely important, and we should listen to them and engage with them and take them into account. But just like when you go on social media and people comment on a JEP story or similar, they are not the whole world, they are not the whole island, and they are not all of tax-paying people in Jersey. I appreciate that not everybody will have taken part in the consultations as well, but when those consultations were carried out by specialist research companies, they look at getting representative groups of people together to try to ensure that there has been wide consultation. So over the last 4 years, there have been focus groups, there's been social media questionnaires, there's been online and phone surveys run by specialist research companies, all trying to ensure that they get a mix of people of different ages as well, because we are talking a lot about age and different generations in this debate, I think. And a clear majority has always come back in favour of independent taxation. And fairness and equality were always at the heart of those views. And they are the official results from the consultations. They're the conclusions that have come back from those. And most of those who I've heard from recently, as I say, who are objecting to this move now and are affected by it, as I say, those views are important and valid, and of course those people have a voice. But I do think it's really important that we point out a few things about many of those. The conversations that I've had, when you do actually start to dig down a little bit, if we're being really honest, Most just don't want to do it. And change isn't easy, and it can be really daunting, it can be irritating, and it takes time and often effort to get used to it. And I really do think that's what we're seeing here in a lot of these cases. And I have huge sympathy for those people, of course I do. And it's absolutely right that we work hard to support them in a transition, as you would absolutely expect. And I would point out, I think, as Deputy Miller did yesterday, nobody is going to be worse off than they are currently because of the arrangements that are being put in place. So really it's coming down to those practicalities. And if I'm being really honest, for me, that is not good enough reason not to take this very important step. It's a step into the modern world with fairness and equality at its heart, just as a majority of those islanders who engaged with those consultations over 4 years asked us to do. There's been a phased approach. I think a previous speaker this morning has talked about, let's take a phased approach to this. We are taking a phased approach, and this has been in process for a number of years. And let's not forget the last Assembly, as Deputy Mezek just pointed out, approved this, the latest step in this phase, on the 15th of September 2021. Members voted 41-2 in favour of continuing with the process of introducing independent taxation. Many of those members are in the Assembly today, including Deputy Farnham, and he voted in favour for it. And my question to Deputy Farnham, that perhaps he could consider answering in his summing up, is what has changed? Now, I appreciate that the previous speaker has just made a point that he believes something has changed, and I appreciate that and I take that point. But I'm struggling to see in the proposition before us today, because this is not on the details that we will be debating in a couple of weeks' time, this is on a very different specific proposition, I'm really struggling to see what has changed. And because of that, how can this Assembly justify, at this stage, scrapping a plan that's been extensively consulted on, overwhelmingly endorsed by this Assembly previously, and which islanders have known has been coming for a number of years? Just because we've reached the most difficult part of the process doesn't mean we should give up now. And as other speakers have said, you know, we're in this Assembly with a great deal of responsibility. But with that comes a responsibility to make decisions in the best interests of our island, even when times may get a little bit difficult. There may be times when we can rightly justify going back to the drawing board, but I don't see any justification here. And quite the opposite, this debate has shown me that we really cannot be complacent about those moves towards fairness and equality that we all like to talk about so much. Just as a final point, you know, this Deputy Mezek, I think, quite nicely made the point that he does believe something has changed since the previous decision. But with all due respect, this proposition, as I say, isn't about the details, and I can't see that anything has changed. This is about the principle of a move to independent taxation, which would effectively reverse that decision that has previously been made. Thank you.
Thank you. Deputy Coles.
Thank you, sir. I'm going to say this, and it's actually very factual, but I did actually speak to my wife before we talk about the matter of her tax affairs, because we have signed up for independent taxation, because it does suit our needs. My wife is self-employed and has very complicated records, which she keeps. They're not mine. We even had the discussion about how I would refer to my wife in this conversation. I didn't like the possessive pronoun of my wife. She is not mine at all. She is herself. But she preferred it to the wife, so I will go with what my wife has said. And when I first want to mention about how the process of actually signing up for independent taxation worked, and it was a nightmare. It was very, very difficult. We missed the first cut-off because of the date we actually got married. Then when we came back round to sign up for it again, there was a bit of a family emergency which sort of took time to deal with, and we completely slipped our minds. It wasn't something that we could apply for when we realised we missed the last one, just put the form in and wait. We had to do it within a particular window. So that became very, very difficult. Eventually, only because I've got elected as a States member and we have our own member of the tax team who helps us with our affairs, was able to submit the form on my behalf, considering another officer had said that I had actually missed it and we weren't going to be allowed to. So it was incredibly difficult, and this is why we may not have seen as many people sign up for independent taxation already. However, does that mean that the compulsory move suits everybody as well? For a lot of people, they will benefit greatly from the move to independent taxation. And these people are some of the more wealthy in our society. There are a lot of people who are currently taxed together on the standard rate of tax, so the 20 means 20, because their joint income is incredibly high. These individuals will be given £18,500 by the tax office for going to independent taxation. They will become better off. So we then have a situation where people who are getting married after this deadline will lose a safety net that exists for married and civil partner couples already in our tax allowances. At the moment, an individual will be given £18,500 for their tax, their personal tax allowance, but a married couple with a single income are given £29,750. Under independent taxation, people going forward from the 1st of January 2022 will lose a safety net of £11,250 because there is not adequate support and protection for people moved to independent taxation. Now, we will hear that, of course, these people who are getting married won't have had that already. But actually, when you get married and you join yourself in a proper union, you take up more risks in things. You may have children. Yes, you'll still have child allowances. Might get a mortgage together. Your outgoing costs will increase. But let's not forget that we don't have independent social security, so we're not actually covered independently should something go wrong. Now, I'm fortunate that in this position that I got married before the cut-off time, so the compensatory allowance will apply to me. However, somebody who gets married this year will not be entitled to compensatory allowance. So, I'm going to go out on a limb here. If Deputy Mezek gets married this year, finds himself in 3 years' time unable to get elected, and unfortunately may have made himself unemployable by some of his thoughts and opinions in this assembly, his wife will be financially responsible for him because he will not get social security that will make up the difference. So actually they will be £11,250 worse off than a couple married before. So I ask, where's the equality in this? We have already said that the people on the standard rate who will then be filing separate will be given £18,500. So I'm just concerned, and this is where Deputy Alves' amendment to Deputy Farnham's proposition helps provide that safety net, so people can choose whether they feel safer to have that safety net or whether they don't. It becomes their choice. The pro-choice proposition, I believe this is better be referred as. That's not to say that we can't have a model of independent taxation that works. Deputy Scott and Deputy Mezek have both mentioned transferable thresholds. It's allowed in British Columbia. It's even allowed in the UK. So there are mechanisms that we can put that will allow people to transfer exemption thresholds. And if that was part of the debate coming up in the next sitting, then I probably wouldn't be supporting this because we wouldn't need to have the safety net because people would be able to choose whether they'd be better off transferring allowances or not. But unfortunately, that is not what is coming forward. And so this is why we need to support what has been brought forward by Deputy Farnham today and Deputy Alves' amendment to that as well. So I do urge everybody to vote for all parts of this. Thank you.
Thank you very much. Does any other member wish to speak? Deputy Rob Ward.
Thank you, sir. I follow that one. I won't pick on my fellow party member in the same way, and I also moved the way I will. My wife, I totally agree with that, and I don't know what I'd say, so I'm going to say nothing. I think that's the best way out of that. So, thank you, sir. So I want to pick up, and there's a very important point here about the individual and income tax as a lone entity. And let me give you an example of a real inequality that affects women. And I hope that in the future, when we look at this, and if something is brought, it is supported by those who have said that if we don't support this, then we are guilty of not believing in equality. If a woman on income tax with children meets a new partner and that partner moves in with them, it is assumed that that partner will contribute to the household because income tax is a household benefit. And so this partner moves in and that assumption is made, and then if they don't inform income support quickly enough, they can very quickly be in line for an overpayment. In fact, the system is designed to have overpayments, that's a reality, and so are likely to have an overpayment. And then that person will be said, you can pay us back £18 a week over time. Now, if it turns out that the partner who moved in is perhaps not the person that the woman thought it was, is abusive or whatever, and then moves away, the person left with that debt is the woman in that relationship. And that's the outcome of our system of income support not being individual. Now, we seem to be happy with that as an assembly. And it seems to be that those who have spoken so strongly, and I agree, about the importance of equality and the importance of independence, aren't willing to address that issue. That needs to be addressed at the same time, and I believe Deputy Tadia made that point. And actually, we had a really good discussion on this, and Deputy Tadia made some very, very good points on that. And I think that's something that needs to be looked at. And that is the point. And the devil is in the detail of these things. Now, if you look at the actual proposition, it does give the option for independent taxation. And if that's what one chooses, one can choose to do that. And this is a classic example of the computer says no again. We seem to have so many systems on our island where our computer system will say, no, you can't do that. Why not? Because the computer can't do it, I'm afraid. I know people will say I'm going on about this too much, but unfortunately this Assembly voted to not stop carpet loans, so there are some people still on the lowest incomes paying back their loans because they agreed that the computer says no. And I would ask members who voted that way to look again at themselves and perhaps and say that needs to be changed, because that was exactly the same argument. And we can't keep doing this with our computer systems. So the ability there for independent taxation is there. And I will say, the way that you fill out your tax form in a modern relationship, and I may have been married for some years, but we have a modern relationship because we are equals. And I desperately hope that that's the way my relationship is seen with my partner. And that's the wrong word, whatever word it is. My significant other, that's a great phrase, let's use that one, sir. But the taxation in this form is, as somebody mentioned, they didn't opt for individual taxation because they just simply didn't have the time. So what I suggest is this. And this is the test of the ability or not of this taxation system to work that is proposed. If we give more time for people to opt, if this is such a good system, people will opt. And I would suggest that the growing comms unit is used to get this information across to people. And by giving people the option for a few years to say you can stay in the taxation system we've had, or you can opt, this will be such a good system when the legislation is brought that people will look at it and say, of course I'm going to opt to independent taxation. All the protections are there. Everything is there. I can express my rights as an individual, and I will opt. But that hasn't happened, and it isn't happening because this is a fudge. And until we address the issue, and I know it's been said before, but I'm sorry, sir, I'm going to reiterate it. Until we have these transferable allowances, we won't have truly independent taxation. And this isn't truly independent taxation. It's two people filing separately and then putting it together. And there is still, and even, so I noticed that, I think it was the minister who said that, oh, but of course, women may well get their husband to fill in their form for them. Or a man may get his wife to carry on filling in his form for him. That's not independent taxation. That's the recognition of a relationship. the nature of the problem with coercive relationships and inequality in this island is much wider than just how we're going to fill in these tax forms. I totally agree that you are not a possession of anything, of anyone, and they're quite right. But that's about genuine equality, and we have massive inequality on this island. We have so many women who have less rights because of their financial situation, working 3 or 4 jobs, second-class citizens because they don't have the same rights as those who are here on different licences or different conditions. And we are sitting here today and saying, because somebody can fill in a separate form, we've nailed equality. Well, sir, I'm sorry, we haven't. And this needs to work. And sir, I have a problem with the fact it doesn't work. And I am troubled with this, sir. I didn't agree with this proposition at the beginning. And when we met and we have our quite frank discussions, one might say, I was dead against it. And we went through it and I listened and we debated. And we need to come back with this in a much more usable form with the allowances, as we've said. So I don't like the guilt trip that's been used. I think it's inappropriate and I think it's doesn't recognise the consistent work that many of us have tried to do in speaking up for equality throughout our careers and whatever we've done. And so until we can put... I wasn't going to mention, but I will mention, on my way in this morning, I saw 2 constituents, 2 people that I know, 2 of the people I represent, who are more elderly in our community, who said to me, you can't vote for this, you've got to vote for the amendment today. And I said, I explained the position, I said, yes. But are you going to win? Are you going to? And I said, well, look, let me say to you, let me try and reassure you, even if it doesn't win, there are compensatory allowances, so you should be okay. I'll come and talk to you then if it doesn't the case, but stop worrying. I should not have to have a conversation with people about worrying. And if the answer is going to be, sir, from a minister, well, they're worrying about nothing. I'm sorry, that's not the way you deal with people. Worries are genuine concerns and you have to deal with people as people. And if that's what's come through after all of the so-called consultation, all of the so-called communication, it has simply not worked, and therefore we are not in the right position to make this change now. We need to give it more time and we need to communicate properly with people. So, sir, I will, with some difficulty over the principles, but Deputy Meswick did explain our position on that, and we did say that at the time, and I stick by that. I will be voting for this proposition, all 4 parts, because I think it will make an improvement and it still gives the option for independent taxation. And I would say to the Minister, please, if you do lose this by having the amendment, please do not throw the classic baby out with the bathwater by pulling everything and saying we've got to start from square one, because we simply haven't. And I, perhaps rarely, sir, agree with Deputy Balash, and I know we are very different politically, but it's simple to extend for a year, extend for another year, give time. And if the system is working well in that time, people will naturally move to that independent taxation because they will have the right to do that. So I think there is a compromise position here that works better for people and deals with their concerns, and there are many concerns. And we have to be cognizant of that. With that, sir, I'll finish. Thank you.
Thank you, Deputy. Honourable Harbison Saviour.
Thank you, sir. I will be very brief. Most of the constituents that have contacted me wish the present system to continue. If people wish to opt for independent taxation, very best of luck to them. And those who wish to stay with the present system, then that's fine too. It could be said that, I have talked this over with my wife, it could be said that I could tell my wife what to do. Good luck with that one. I've been married well over 34 years and that's not happening. But it's, I don't have a problem referring to my partner as my wife. It's not a declaration of ownership, it's a partnership. And I am her husband. And long may that continue. But it's just having the balance there that people require. Not everybody wants to rush headlong into this this brave new world, if you like. But I don't have a problem. I'm all for equality, but I will be supporting this proposition, sir. Thank you.
Thank you, Deputy Luce.
Thank you, sir. And as with many subjects, important subjects like this, there are strongly held views on both sides. And we've heard that from speeches in the Assembly, and we've heard that in letters from the public some years ago, not that long ago, letters in support of independent taxation, quite rightly, and more recently, those who don't wish to be taken down this road. And I came to the Assembly yesterday, sir, with a clear view that I was going to support this compromise, which I see it as a compromise proposition from Deputy Farnham, because it says, and we need to read it, independent taxation should not be mandatory for married couples and civil partners who currently complete a joint return and who choose not to elect. So no obligation there, no mandatory obligation to do anything. Part B, to request the Minister to take the necessary steps to ensure joint taxation remains available for those who wish. Nobody being forced to do that. And finally, to request the Minister to take the necessary steps to modernise joint taxation. Deputy Mezek's quite right. We need to continue to modernise this taxation, but the Minister to do that, to ensure that married couples and civil partners who choose to remain subject to joint taxation will have shared responsibility for their tax return, and that both parties who do that tax return will be required to sign. Gender neutral, completely equal across the board, both sides take the same level of responsibility. And then we come to the debate, and I wrote down a few things there. Joint taxation does not exist in law. The wording of this proposition is ambiguous. Is this proposition actually legal? Surely married man's taxation is done away with Part C. In my view, as I said, it's gender neutral. So is it right that because the law is so outdated, we cannot actually legally bring this proposition into being today, sir? Well, I don't believe that two wrongs make a right. And I believe with this proposition, it's a common sense compromise position that we need here and now to move forward. That doesn't force anybody to do anything. It moves in the right direction, and I would urge members to support it. Thank you, sir.
Thank you, Deputy. Deputy Doublé.
Thank you, sir. And I will respond to the previous speaker because it's very tempting when somebody rises and says this is a compromise. And I can understand why members might think it's a compromise, because I think as a government, I do think we need to hold our hands up and say there is perhaps a better way we could have communicated some of these changes. The intention behind them is absolutely the right one. And I think from the speeches that we've had today, we all share that principle of equality, or I really hope we all do. But this is exceptionally complicated. And the Constable of St. Martin and I had some meetings. It was quite a few years ago now. And we fought very, very hard for this change with other deputies at the time. And it was something that was really hard won. And I recall being in meetings with the Treasury Minister at the time. And it's a huge area of law and policy to try and get your head around. And some of the points that were raised by members in the debate yesterday, and some of the questions being asked of the Attorney General about, okay, could we have heterosexual couples having the same system as same-sex couples? We asked all of those questions at the time, and we gave that challenge, and we tested a lot of the thinking. And I believe we did get to a place that we were happy that actually we managed to, as backbenchers, we managed to convince the government at the time that independent taxation was the way to go. And for some of the reasons outlined by my colleagues in Home Affairs yesterday, because of those horrific abusive situations that so many women, a lot more than you would really be able to conceive of, and women from all different income levels and all types of backgrounds are currently being subjected to financial abuse and coercive behaviour within relationships. And we are facilitating that with our laws. So this was a really hard-won battle. And actually, it wasn't a battle, because we came together, the backbenchers who were fighting for this. We were listened to by at least some members of the previous government, the previous minister who happened to be a woman. We found that common ground. But I do see that it's not perfect. perhaps the communications could have been better. I think there's some fear amongst certain sections of our population, and that fear has been quite rightly communicated to us. And people have been petitioning us perhaps not to do this. But I think, as Deputy Stevenson said, that's a small minority of people. And actually, what I want to do is take the Assembly back to first principles and look at the balance of harms that might be being caused by this. And actually, I think the principle of equality, it has been spoken about before, and I'm not going to go into that again because I think that has been established, actually. So I'm going to touch on the balance of harms. So there are two harms that the members bringing the propositions today are pointing out to us. And as a government, I'm part of the government, so I'm an assistant minister. I'm listening to that. And I think it's important that we aren't in these factions of government versus backbenchers or government versus party. I think it's really important that we actually listen to each other and that we are able to change our minds and are able to say during a debate, okay, I've listened to those points and I'm going to go back and talk to my officers and perhaps do this a bit differently and take on board the points that have been made. So the two problems that are being raised with us today via this proposition is problems with filling in the tax form. Okay, and again, previous speakers have covered this, and I think have covered off those points. For example, if you're a woman married to a man who has always filled in the tax form, of course he's going to help you. Of course the government are going to provide help for people to fill in those forms. That to me is not something, that's something that is easily solved. The other problem that's being raised with us today, and again, we're listening, is the financial impact of the not having the compensatory allowance going forwards. Now, I think it's really good that government provided that compensatory allowance at all in the first place. That's not something actually that we had to do. That, I think, is government, and I think there's an overlap, wasn't there, between the previous government, who kind of set the course on this, together with the backbenchers, who were calling for it. They were trying to effect this absolutely critical change, which we must do. They were trying to effect that change in the most practical way possible because, and again, Deputy Rob Ward, I fully take his point about the computer says no argument, because I remember as a backbencher hating that that response. You know, if I was trying to make some change and calling on the government to do something and getting the response, well, our computer systems won't allow it. And I don't think that's exactly what government are saying. My understanding of it is, it's not about computer systems, but I think it is about cost as well, and we do have to be realistic about that. If we go with this proposition today and we approve it, and indeed, if the Treasury Minister doesn't decide to just pull the idea of independent taxation altogether, because there is that risk, I'm very worried about that, we might end up with 4 parallel systems. So we might have still this married man's taxation that people either want to opt into, or are still in it through inertia, or are still in it because they're in a coercive relationship. And then we might have the separate assessment tax regime. And then we would have independent taxation that was mandatory for couples that were married after 2022, 1st of January. And then a 4th, independent taxation that was optional for existing married couples. It's very complicated. I'm not sure that we all actually really have a grasp on what the system will look like if we approve this proposition today. I think it's going to be a big mess, and I don't think it's going to achieve furthering equality that I think we all really want to achieve. So what I am asking today, and I'm asking my colleagues in government, I'm asking the Treasury Minister and the Assistant Treasury Ministers to listen to the backbenchers, because we're all members of this Parliament, backbenchers or government party or not, and we need to listen to each other. This is a debating chamber, it's not an arguing chamber. We shouldn't be coming in here having already decided how we're going to vote. and having already decided, okay, my allegiance is with the party, I'm voting with them, or my allegiance is with government, I'm voting with them. We should be open to changing our mind. And so I'm calling on my colleagues within government. I do think that members should vote against this, and then I would like the Treasury Minister and the Assistant Treasury Ministers to come back with some solutions, with some clear ways that people will be helped with filling in their forms, with some clear options, perhaps for the transferable tax allowances. Again, these ideas have been discussed by backbenchers. I think there's some good ideas there. And do what the Constable of St Martin and previous deputies and myself did, and sit down together in a room and discuss those ideas and listen to each other. And I think we can get to something that still will achieve that independent taxation. We must not delay that. And actually, what I want to do is read out something that the Women's Refuge have shared with islanders this morning, I believe. Because, of course, the Women's Refuge are in touch with some of the most vulnerable women in our island that we don't get to meet every day. Jersey Women's Refuge wholeheartedly believe that Jersey should move to independent taxation for every individual. On a voluntary joint taxation basis, and I think they mean by that on a voluntary married man's taxation basis, women subjected to controlling and coercive behaviour stand little chance to attain financial independence. The systems around women's rights need to be wholly fair and enable them to live freely. Independent taxation is crucial for safeguarding women's rights and protecting women from domestic abuse and financial coercion. The current system leaves women vulnerable to abusive situations. We see evidence from survivors of economic abuse that it causes immense devastation to their lives. It is a very real issue. Independent taxation is an essential tool in breaking free from abusive relationships and establishing a safer future. Independent taxation grants women financial autonomy and the control necessary for their well-being and safety, and contributes to a more equal society. Jersey must be a place where women are empowered to thrive, free from the risk of financial exploitation and abuse. So I will just read, that's one of those sentences again. Economic abuse causes immense devastation to their lives. And I want members, when they vote today, to think of the balance of harms. We have immense devastation, some very vulnerable women and children in those families as well. And we have difficulties filling out tax forms, which we can help with that. And some financial impacts, which I think we can find some other options to help with as well. Please vote against this proposition. Do not delay the independent taxation changes any longer. Thank you.
Thank you, Deputy. Deputy Alves.
Thank you, sir. I'd like to start by actually thanking Deputy Farnham for accepting my amendment. My amendment, which is now paragraph D, seeks to level the playing field for all married or civil partnership couples, regardless of when they entered, when they got married or entered a civil partnership. A lot's already been said in this debate, and my party colleagues have actually addressed a lot of the things that I was going to say. So I'm going to use this time just to address directly the comments published by the government in relation to my amendment. But before I do that, sir, I want to address the use of the term married man's threshold and taxation, which I've heard a number of times during this debate and was also mentioned in the comments paper. Sir, I can categorically say that I have never heard it referred to as the married man's threshold until now. It's always been the married exemption threshold with an extra allowance for working wife, which later became the second earner's allowance. And in fact, this is the language that is currently used on the gov.je website, and I've looked as far back as 2011 at the allowances and the thresholds. I've even checked my own copies of my past tax forms, which I'm sure probably won't surprise a lot of people. I do keep. And nowhere on these tax forms is there any reference to this married man's taxation. So if this is the correct terminology, I'd like to ask, why is it that the government itself is not using this terminology in its own publications and its own documentations? I don't understand to what end. What is that achieved by not using the correct terminology, but now using it in this debate? So going back to the comments, the comments started by saying that what's being proposed effectively undoes the decision of the last Assembly to make independent taxation mandatory. This provides a choice. We've seen a lot of decisions from the last Assembly being undone during this term already, for one reason or another. And I think, as my party leader mentioned previously, my party and I did agree on the principle of independent taxation in the last term. However, this was agreed on the premise that when the detail behind this came forward, no one would be losing out financially. And unfortunately, this is not what has happened. As a member of the JCRT, I'm aware that the Home Affairs Minister appealed to the committee to comment against this proposition. We had much discussion, and ultimately the conclusion that the JCRT came to was this. The JCRT are strongly in favour of independent taxation and are concerned that whatever the outcome of today's debate, its implementation is not overly delayed. The trustees believe independent taxation is essential to the progression of equality for women and, very importantly, to free and empower women living in financially coercive relationships to live life how they choose to. However, the trustees also believe it is important that independent taxation is delivered in a way that does not create new inequalities. And that is exactly what my amendment, which is now paragraph D, seeks to eliminate. Sir, I cannot dispute that it is archaic that a woman or second partner should have to have their partner's permission to access their tax affairs and complete their tax information for them. I am all for and fiercely in favour of independent taxation as a way to enable ownership and access to our own tax records and contributions. And that's why I'm glad, actually, that, and I think this has been mentioned a couple of times already, that Deputy Farnham did amend his proposition to now include paragraph C, which asks to take the necessary steps to modernise joint taxation returns. Whether that's the right language to use or not, I think it's quite clear what is meant in that paragraph. However, as the JCRT has highlighted in my earlier quote, I am not prepared to support something that will make some families financially better off than others. Now, £3,000 a year loss may not seem like a lot to some members of our government, but I can assure you it makes a big difference to families. The comments go on. Among the administrative complexities that this amendment would introduce would be the need to understand the income of both spouses and, where necessary, match to independent taxation tax returns. Deputy Mezek mentioned this earlier. The government have said that they will continue with compensatory allowances for those married prior to January 2022. Surely, in order to ensure that these couples are financially not worse off, does this not mean that they will need to understand the incomes of both spouses and match the two independent taxation forms? Anyway, so surely this is contradictory. The compensatory allowances being proposed by the government only applies to those married or civil partners before January 2020 and who are already on the island, whilst those who are married or civil partnered after this date or before but have moved to the island since will be financially worse off than their counterparts. Surely that's not fair. My amendment seeks to level that and apply that to all couples regardless and ensure a consistent and fair approach across the board. The comments go on and they state that creating optionality over tax allowance would be technically complex to achieve in our revenue system and complicated to administrate and to explain to the public. Well, sir, I'd like to inform people that actually optionality already exists in our tax. For example, the child allowance thresholds are transferable between parents, whether they're married or not. So I've dealt with a number of constituents who have children with previous partners or partners, where the main parent earns below the threshold and therefore transfers the child allowance to the other parent in order to allow them to have that extra allowance. So, for example, if somebody has 3 children with 2 different previous partners and neither of those previous partners earns above the threshold, those 2 previous partners can transfer that child allowance, so that's 2 children's allowance, to the other parent, who legally then nobody is in a relationship with or has ever been or could ever be said legally that they were in. But those parents have taken that decision. If this is possible between 2 taxpayers who are not in a legally binding relationship, why is it that what's being proposed here is so difficult? I would argue that actually it isn't. Maybe it's just inconvenient. I can assure members that I do not wish to enable inequality based on marital status. However, the government is doing this between couples by allowing some to benefit from a compensatory allowance and others not. Furthermore, they've stated that my amendment defies the long-term held policy of keeping our tax system as simple and as fair as possible. How is our tax system simple and as fair as possible when we currently have 2 different systems? That's called the marginal rate and the standard rate. That's completely contradictory. Why, again, like some other contributors to this debate have already said, why does the government not apply the same simple and fair system across the board to all areas, including income support, where a household income, regardless of marital status, is taken into account and assumptions are automatically made that household members will contribute equally or wholly, as Deputy Tadia mentioned yesterday in his debate. Ultimately, by not supporting this proposal, it could be said that the government's position proposals is a way of raising revenue for those who can least afford it in our society by stealth, while the government is happy to state, quite clearly on the gov.je website, that they are happy to lose £4 million from high-earning households by making this move. What about the revenue that's being raised by making this move from Middle Jersey? So I urge members to look back again at my report and the example that I've shown in it. This proposition will enable families not to lose out financially by giving them a choice to elect for the financial benefits of being married, being in a marriage or a civil partnership that others are benefiting already. So had the government allowed all thresholds to be transferable between households, I would have not have needed to bring forward my amendment, and I would have 100% supported the government's position. As such, independent taxation in the form that it's being proposed and brought forward will cause financial loss to some families to the system that was compared to the system that was in place prior. Is that what we really want to do, sir? To cause some families to be financially better off than others? If members want to truly support families and give people the choice, I would urge them to vote in favour of all parts of this proposition. Thank you, sir.
Thank you, Deputy. Does any other member speak on this proposition? Yes, Deputy Renouf.
Thank you, sir. Sir, members will be, I'm sure, familiar with the works of Niccolo Machiavelli. Some members perhaps more so than others. Machiavelli's most famous work was The Prince, and it was on the problems of political leadership, albeit from the perspective of the medieval era. Those days are long gone, but the reason Machiavelli is still talked about today is that some of what he wrote is relevant through the ages. We usually think of Machiavelli as a proponent of devious and manipulative political workings, and therefore entirely alien to this assembly. But his work also contains many insightful comments about the realities of politics, which do remain relevant. And one in particular came into my mind over the weekend, because as I thought about the correspondence which members have received on this issue. Machiavelli said, "There is nothing more difficult to take in hand, more perilous to conduct, or more uncertain in its success than to take the lead in the introduction of a new order of things. Because the innovator has for enemies all those who have done well under the old conditions, and lukewarm defenders in those who may well do well under the new." Now, Machiavelli was obviously talking about revolutionary change, a new order of things, but I think his argument applies more generally. Basically, he was saying that whenever you introduce change, you can expect a great deal of resistance from those who feel threatened by it, but you get very little support from those who benefit, because they do not necessarily see that they will benefit and may even not be paying attention. I think that's the case here, sir. We have received many letters from those who do not like the change to independent taxation and would rather stick with married man's taxation, the current system. We have heard little from those who are comfortable with the change or who actively support it. I want to bring their voices back into this debate, and I want to advance two arguments, one on principle, that I'm against the proposition in principle, and second, that I'm against it on the ground of practicalities. In both cases, I have in mind the majority of people in this island, including those individuals who have not written to us and whose points of view are not mentioned in the proposition. We need to think about all of the island in this debate, not just respond to a minority of people who have reacted against the new system. First, the principles involved. In 2021, the previous Assembly passed the principles with, I think, just 4 votes against. The reason for that was clear. Married man's taxation is utterly archaic. The damage done by this kind of institutionalized belittling of women is serious. Married man's taxation is archaic because it dates from a time when women really were treated as inferior. And it survives as a rather grim reminder of those times, and a grimness that is reflected in the way that it gets reported outside this island. So some members have objected to the use of the term married man's taxation because it's not on the official forms. I think the reason it's described as married man's taxation is because we need to define what it really is. It is a description of what the system is. It is not joint taxation. Joint taxation implies equality. This is not equality. It is married man's taxation. That is the reason why we care about this description, this descriptive phrase. And the survival of married man's taxation is also a reminder that the work of women's equality is not yet done. If we were to vote to maintain it as an option, as the proposition says in Part A that we should, until some other system comes into place, it says to society that we are comfortable with this situation continuing. We think that this kind of legal repression of women's rights isn't that big a deal. It's just a matter of consumer choice. But this is not a technicality. Laws such as this ripple and reverberate through society. We have heard from Deputy Miles and others about the ways in which taxation laws can reinforce the repression of women at the hands of abusive husbands. It's no use putting your fingers in your ears. Married man's taxation is a contributory factor in economic abuse. Deputy Balash argues that this is not the aims of those supporting the proposition. Of course it isn't. He's entirely missed the point. It is an unintended consequence. His argument reveals a disturbing lack of understanding of how repression of women works. Under the new system, both parties in a marriage will have to agree to file a joint return. That is the problem. In the real world, abusive men will compel their wives to continue with the old system. That is how abuse works. These kind of messages matter. That's why, for the overwhelming majority in society, independent taxation is supported. They get it. We know this is the case because there was detailed consultation about the move to independent taxation. It's also why the overwhelming majority in this assembly supported that move. Independent taxation treats everyone equally, regardless of whether they're single or in any kind of relationship, whether that's living together, civil partnership, or marriage. That is why I cannot support Deputy Farnham's proposition in principle. It perpetuates married man's taxation, and therefore, in principle, I reject it. And so to my second argument, which is about practicalities and proportionality. We need to spend a little more time looking at the proposition we are actually voting on, because it's a real dog's dinner. An unappetizing mixture of expediency and ad hocery designed to cover as many bases as possible, but without understanding the full implications, which are considerable. Part A says that independent taxation should not be mandatory for anyone who hasn't already chosen to elect for it. Keep the existing system, in other words, for anyone who wants it. Part B says that we must ensure that the present system remains available into the future. The existing system. Part C goes much further and calls for the present system to be modernised. And Part D would extend allowances, transitional allowances, into the future for all married people. Part C seems to have been added because Deputy Farnham belatedly realised the damage that his proposition as it originally stood would have caused, because it would have perpetuated the present system. Now he wants it to be modernised by creating a new system of joint taxation. Deputy Al's amendment takes us still further away from independent taxation and into a world of mind-boggling complexity. It is based on the idea that people who have moved to the island since 2021 or got married since should also have available a compensatory allowance, even though they've not ever had the married person's allowance. Third, you cannot lose what you have not had. Compensatory allowance is to compensate for a loss as we move to a new system. People who have got married since 2021 will be part of the new independent taxation system. They will benefit in some circumstances. For example, if they are cohabitees compared to the existing system. But they will not get compensatory allowance because that would remove the whole point of independent taxation. To call this a loss is to see the tax system as entirely static. But tax systems are dynamic. As independent taxation becomes the norm, then tax allowances will no doubt move to favour this. But they can't move that way if you're preserving the old system, because you've already chosen to favour marriage. It's one or the other. Either we have a tax system that is biased in favour of marriage, or we treat people as individuals. So we need to be clear about what this means. The sum total of the changes in the proposition would be to effectively abandon independent taxation and replace it with some form of joint taxation that is yet to be determined. It is not independent taxation if the moment you get married, you have available compensatory allowances equivalent to the old married couple's allowance, and that this continues indefinitely into the future. That is joint taxation by way of compensatory allowance. You can, in name, have independent taxation, but if you preserve marriage allowances, then obviously people will choose that when they get married. It's a bogus choice. So Deputy Farnham's amended proposition will take years to implement whilst the new system is prepared, consulted on, goes back and forth, and so on. And you know what I'm prepared to bet will happen at the end of that? At the end of all that, a proposition will be brought before this Assembly to bring in the new system, will it not? And someone will jump up and say, why are we disadvantaging so many people and cohabitees? Let's move to independent taxation. Because it is the simple, obvious system to go with. Because let us remember who the current system is biased against. It is biased against cohabitees. If we preserve the allowances, then we preserve the bias towards marriage. Individual taxation removes that bias. So what is the problem that Deputy Farnham is seeking to overcome? Like all of us, he has received lots of emails and letters from mostly elderly residents saying that they would like to stick with the current tax system. It's portrayed as an issue of choice. And who, after all, is against choice? So let me take on this argument about choice. Not all choices are equal. I can choose what TV programme I'm going to watch in the evening and have no impact on wider society. It's a matter for myself and my family. This is consumer choice. But choosing to perpetuate the old tax system or adapting it is not just a matter of choice for the people concerned. It is a different type of choice because it makes demands on all of us. It is a matter for all of us because it has consequences for all of us. Partly that's because of the belittling of women that preserving the old system represents. We will still be seen in the eyes of the world to be that idiosyncratic or even backward place that still allows women to be chattels of their husbands. But it also affects us more directly, because we'd all have to pay to create this choice. I won't go through all the reasons why, but to maintain what is in effect multiple different taxation systems will cost money. Millions of pounds to set up, with a substantial ongoing cost in assessing tax returns submitted under multiple different methods or categories. Those costs are unavoidable, and those of us who are ministers who've sat in the Council of Ministers have heard the Controller make very, very clear what those costs will be. I say, sir, it is frankly bonkers for a small jurisdiction to try and run systems of this complexity together. So what exactly is the loss against which people wish to be protected? Why are we going to all this trouble? What the proposition seeks to protect people against is hassle. The undoubted upset and worry that comes with having to fill in a tax form. Now, I do not minimise the fact that this will cause problems for some people, even with all the help that will be available to those who need it. But, sir, when it comes to weighing these things in the round, I do not believe that the hassle factor weighs heavily enough in the balance to justify the extra organisational complexity, financial cost, and reputational damage that this proposition involves. We need to move on. Our duty is to think about the island as a whole, not just those who have contacted us. I hear what they have to say. I understand that it is something they would rather not have to do, and I understand that it is annoying. But there are better ways to deal with the issues they raise than throwing out the move to independent taxation. The fact is that their choice is not a free choice. It imposes costs on the rest of us. It will cost us reputationally, it will cost taxpayers in administration, and it has damaging consequences for vulnerable women in society. All to perpetuate a system that the island has decisively rejected, whilst we try and create a system of joint taxation. I disagree with that. Independent taxation is the way forward, simple and fair, with compensatory protections in place. So I started with a quote, and I'll finish, if I may, with a misquote. It comes from Chesterton, who was speaking about the ignored majority who do not speak up, the silent majority, if you like. We are the people of Jersey, and we have not spoken yet. I think we should listen to those people who have not spoken, and I urge members to reject this proposition.
Thank you, Deputy. Does any of them speak on this proposition? Deputy O'Brien.
Thank you, sir. I've been financially independent since the age of 15, so I've therefore filled out my own tax return and moved along swimmingly in life. When I got married, that all changed, and yes, I was still financially independent, and yes, I still carried on filling out a tax return. So that didn't actually change. However, of course, my status did, and it meant that I became the responsibility of someone else. I don't particularly like that idea, sir, and I never have. Not because there's anything wrong with that status, but because it is a bit ridiculous. We are now in 2023, and I believe that we should all be treated independently as individuals. And therefore, I would not be in favour of supporting this proposition. But the more important thing is that we signed up as part of CEDAW. And for me, that fundamentally, when Deputy Labby mentioned that yesterday, whatever thoughts I had previously, because I had sort of thought about various different things, but particularly because we have had a number of people actually come to us and raise concerns about having to fill out tax returns. And of course, there is always that concern. But there will always be some time in somebody's life that they're going to probably end up in that position. But we signed up for that, and we signed up because we believe women have to be equal in every single place. People have talked about various things, and somebody mentioned about choice. But what exactly is choice? And who is making that choice? Who is actually making that choice when the form comes in? Who's going to make the choice? Are we going to have a member of the tax department sitting against them to make sure that those people are actually making that choice? I've asked questions in this assembly, by way of written questions, about coercive behaviour and what training people get in relation to that. Because let's be fair, it's not something that's easy to identify from even those people who are actually trained to do that job. But going away from that as well is the fact that things have to be as simplistic as they possibly can. I've studied law, I've enforced it, and I've taught it. And there is nothing worse than having legislation that is complicated. And so people have mentioned social security, and yes, it is complicated. It's certainly complicated when you go along and say, I'm now no longer have a job because actually I've been forced to retire because of my age. And they say, oh, well, I'm sorry, but you've still got to carry on paying social security, but maybe that's for another day. But the point is law has to be simple so that we can all understand it. Not only the members of the public, but when I go into the tax department, they have to understand that the legislation that they've got is relevant to all. Not, well, if you're in this system, this applies to you. If you're in that system, that applies to you. And if you're in the other one, that applies to you. It has to be simple, sir. It has to be simple so that those people who are actually going to be potentially advising people and potentially enforcing that legislation as well, it has to be simple so that the people who are actually the residents understand it so that they don't break the rules, and the tax people are able to advise people so that those people don't break the rules. So we can't have 6 different systems, and we have to have independent taxation. And I've listened to particularly what Deputy Dublé said, and it is a fact that we have to ensure that people have rights, and their rights are independent to themselves, not to anybody else. So from my perspective, A, the fact that we've signed up for CEDAW, and that to me is fundamental, and we need to move forward. And B, as I said, everything has to be simple so that people understand it, because if it's not, nobody will. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak on this proposition? Deputy Gorst.
Thank you, sir, and I'm pleased to follow the last speaker around CEDAW and simplicity. My fellow deputy, sir, as we all know, is charming and persuasive, and he portrays his proposition in a simple way, which is that there are a large number of islanders who do not wish to move to independent taxation, and therefore it is perfectly reasonable, and we heard Deputy Balash make exactly the same case, it's perfectly reasonable to give the choice. And I find myself in rather a strange position this morning, because I would normally be arguing around freedom of choice. I find myself also in a strange position because my parliamentary colleagues to my left, even though they're sitting on my right, are not supporting the move to independent taxation, even though they did, as they've said, in principle. And so I'm always one to look for the positives, and the positive that I take from the debate this morning is that by broad brush, although there are exceptions, and I'll come to that when we come to the wording of the proposition, by broad brush, members would like, let's say with a fair wind, would like to move to independent taxation. But we have heard many caveats about why now, with this model, might not quite be the right time. And I pick up on what Deputy Le Hegrier said about CEDAW, We as a community took a long time to move to the point of signing up to CEDAW, asking the UK to sign on our behalf. And even then, we had to make reservations because we knew there were some substantial gaps in our legislative provision in order for us to say we were compliant with that international treaty. And the reason that we took a long time to sign up, and backbenchers in this assembly roundly chastised previous governments for not signing up, was because of this particular difficulty. We have, whether we want to call it joint taxation or we want to call it married man's taxation, the legal substance, whether over the years we've tried to use nice terminology more in keeping with our community inclusiveness, the legal substance is that we currently in Jersey have a married man's tax allowance. You have to look through all of the detail of the legislation to see where spouse A turns from sounding rather cuddly, or spouse A. You have to read through all of the small print to get to the point that as a matter of law, a married man is the person that submits a tax return on behalf of his wife. That's what we have. But we try to talk about it nicely. So let's just be clear about that. And that was our big stumbling block to signing up to CEDAW. As the Attorney General reminded us yesterday, we took a reservation, and that was the right thing to do. But that reservation made a commitment that we would move to independent taxation. Not at that point that we would move to a joint taxation, but that we would move to an independent taxation. When I became Minister for Treasury and Resources, it's quite well known, it's not a job that I greeted with open arms and abundant joy, because of some of the difficulties that department faced. And some of those difficulties, let's be clear, are in Revenue Jersey. What I have found in Revenue Jersey is excellent people seeking to serve islanders in the best way that they can. But it is, and I never really realised, perhaps because I am an accountant, just how complicated islanders find our tax system. And that has been brought home to me during the course of this debate, because we have heard, I didn't want to pop up every time a States member was misrepresenting the tax system. You would have been very tired of me, sir, doing that. But what it's shown is that even in this assembly, the body responsible for maintaining the legislative base of our tax system, it is little understood. Because I find myself in the same position as Deputy Balash and the Constable of St Saviour. The legal reality is I am not making a joint tax return. And when his wife said to him, I'm not sure how many years ago, I won't remind him when mine said to me 26 years ago, well, yes, of course you can do my tax return, darling. The legal reality is it wouldn't have mattered whether she had said, oh, of course you can do my tax return, darling. I am responsible and I am the one on the hook for making that return and meeting that tax liability. And whether my wife likes it or not, the current legal situation is that she is subjugated in this regard to me. And that's the inherent unfairness. And that's the reason I think that previous assemblies voted for independent taxation. It wasn't, I'm reminded today, back in 2014, when the then Treasury Minister published a tome around modernisation of taxes and where we were and what we could do. independent taxation was mentioned even then. And it's been a long road to get to where we are today. And my fear is, sir, that with all good intention, we are about to depart from that road upon independent taxation. And rather than supporting my officials, I'll come back to that point, the need to simplify the system so that officials can better communicate it, so that islanders can better understand it, what this proposal does is make it more complex and more difficult to understand. Lots of speakers today have said, well, the government is making a big play about correcting an injustice and a discrimination in regard to the tax system. But look at 5 other injustices and discriminations we've got over here. Why are we not addressing those this morning? Why are we only focusing on this one? So let's not change this one. Let's not focus on this one. Let's just say, oh, we've got a lot of terrible discrimination and issues that we need to address, and we'll keep them all together and we'll address them on some future date. That's not how government works. It's not how legislation works. We have the discrimination in front of us, we have the difficulty in front of us, and we must make the decisions in order to address it. And I come to the wording of the proposition. Others have spoken, my colleagues have spoken eloquently about the compensatory allowances. Deputy Mezek said it was a fudge, one of the renowned Jersey tax advisors. Perhaps I should declare an interest that we use that individual as a family, said that this is just a fudge. This is not really independent taxation. Of course, we know that every grandfathering regime that you have to put in place to some extent is not the end state that you're getting to. You are introducing the legislative state of independent taxation, but to seek to ensure that lower income families are not disadvantaged by the move from the old system to the new one. You put in place a grandfathering system, which you can describe as a fudge. That's all grandfathering systems. But what it does is seek to protect lower income families. And I would hope that my colleagues, as I say, to the right, would have supported that proposal. I'm running out of time as I'm not the main responder. The proposition as it stands, and I'll read it out, so it says, the independent taxation should not be mandatory for married couples and civil partners who currently complete a joint tax return. Well, none of them currently complete a joint tax return because there isn't such a thing, but let's take it in the spirit in which it was meant, that currently the man completes on behalf of the wife, and who choose not to elect for independent taxation prior to that, to request me and the team to take the necessary steps to ensure that joint taxation remains available to any such married couples and civil partners. Well, it doesn't currently exist, so we would, and the reason I say this, we need to go away and think about a joint tax regime. And why do I say that is the case? Because we get to see to request me and the team to take the necessary steps to modernise joint taxation returns to ensure married couples and civil partners who choose to remain subject to joint taxation will have shared responsibility for their tax return, and that both parties to the tax return will be required to sign. So what this proposal actually does is, on the one hand, it says, well, yes, we'll introduce independent taxation, but people will have a choice. But on the other hand, Minister, you've got to go away and introduce a new joint tax regime and modernise that. And that's quite important that we understand that, because if members support this today, we will not simply be able to, as the Deputy Ballas said, by the stroke of a pen, bring an amendment to P41, I think it is, at the next state sitting. No, we will withdraw P41. I hear hoorays around the chamber on behalf of some, but let's just be clear, we will have to withdraw P41 to be able to go back and do the work. Now, The previous government, when it was doing its consultation and its focus groups, those people there said no, they wanted independent taxation. They didn't want a modernisation and the creation of the joint tax return. That's not quite what I'm hearing from members today. We will withdraw that, or my Assistant Minister will withdraw her proposal, and it will take us months, if not getting into years, to go away and bring forward a new joint tax regime. And we'll have to think about how that fits, or if it's possible to have joint and independent regime at the same time. And the reason I say that as well is because at D, we've now got Deputy Alves' amendment, which says that for those who married or who entered into civil partnerships after the 31st of December 2021, and that those who married or entered into civil partnerships after December 21 and moved to the island after this date are automatically assessed independently for tax, there should be the ability to opt for application to the current marriage and civil partnerships exemption thresholds and allowances, which earlier in the proposition we are asked to modernise and create a new joint system. So we'll be left in the situation where we have a new joint tax system. Now, the ministerial team can go away and we can do that work because we're in the hands of the Assembly. The Assembly is supreme. But I have to be clear with members, that does not work with an independent tax regime. We are saying no to independent tax, we're saying yes to something else which is a joint tax regime, and we can go away and do that. But what I want to say to members is, and I've spoken to the Assistant Minister, we are in the ministerial team and we do hear what members are saying. And some members have said they would prefer to think about transferable allowances rather than compensatory allowances. They probably would be more complex, but they could work instead of compensatory allowances, or they could have a system that works alongside them. Deputy Alves, really at the heart of what she is asking is that there is an advantage, a tax advantage to married couples by having a different allowance for married couples rather than treating everybody as individuals. We in Treasury are absolutely prepared and committed to going away and working with any individual. And Deputy Mezek said, well, he likes independent taxation, doesn't like the nuts and bolts of it. Well, we will work with members who've got concerns, who would like to see modifications to what was proposed at the next state sitting. And in the spirit of that, the Assistant Minister said, no, she will defer the proposal for the next state sitting till after the summer recess so that we can do that work and we can work with members. But I must be clear in 2 seconds, we can't do that if members vote for Deputy Farnham today, because what he's asking for is something totally different. Thank you, sir.
Thank you, Deputy. Does any member speak on this proposition? Yes, Deputy Morrell.
Thank you, sir. I'll keep it very short. But having listened to the debate, a few things have struck me, and I couldn't help but think about perhaps Deputy Farnham's most recent proposition, which he brought to the Assembly, about whaling in the Faroe Islands. And I remember then standing up to speak, be careful when you try to take the moral high ground, sir, because it does make others look more closely at yourselves, and they will find within us kind of moral ambiguities and places that they believe Jersey shouldn't be. And so it made me think, if I were sitting as a member of the Faroe Islands Assembly, knowing that my Chief Minister or the equivalent of had received a letter from Jersey talking about the barbaric practice that they undertake on the beaches of the Faroe Islands. If I were one of those members of their assembly, sir, wondering who was this island to come and tell us how to live our lives, I might look at that island, Jersey, sir, and think, well, if they were to support Deputy Farnham's next proposition, the one before us right now, they are continuing, sir, to maintain a situation where women over 50% of the population, sir, are condemned to be nothing more than the chattels of their husbands, where women are not protected from coercion within relationships or financial coercion. And I can tell you, sir, if I were a member of that Faroe Islands Assembly, having received a letter from Jersey about their barbaric practice of slaughtering dolphins and whales, I would be highly motivated to write straight back to the Chief Minister of our island, pointing out the awful hypocrisy that we have when we talk about the slaughter of whales, but we do not defend the rights of women. And why do we not defend the rights of women in our island, sir? Because we don't like form filling. It appears to me that that is at the core of this argument. We don't like to fill in a form. Therefore, we will condemn women to a secondary status in our island. I just thought the Assembly should reflect on that, given that clearly the Assembly has very recently decided to adopt the moral high ground in respect of the Faroe Islands. And I then just wanted to finish by saying, for anyone who is doubting the reality of coercive control, because I heard the Constable of St Saviour talking about his relationship with his wife, and I'm delighted they have a wonderful and happy, loving relationship. It's fantastic. But that isn't something that all of us in this island are able to live in. And Jersey's Women's Refuge has publicly said today, sir, that they wholeheartedly believe that Jersey should move to independent taxation for every individual. On a voluntary joint taxation basis, women are subjected to controlling and coercive behaviour, and they stand little chance to attain financial independence. The systems around women's rights need to be wholly fair and enable them to live freely. Independent taxation is crucial for safeguarding women's rights and protecting women from domestic abuse and financial coercion. The current system leaves women vulnerable to abusive situations. We see evidence from survivors of economic abuse that it causes immense devastation to their lives. It is a very real issue. Independent taxation is an essential tool in breaking free from abusive relationships and establishing a safer future. Independent taxation grants women the financial autonomy and control necessary for their well-being and safety, and contributes to a more equal society. Jersey must be a place where women are empowered to thrive, free from the risk of financial exploitation and abuse. I personally agree with every single word in there, sir. I personally believe that our rights for every single human being in this island, those fundamental human rights that parties in this Assembly claim to defend, must be defended, sir, by every single one of us. And form filling is not an excuse to deny those human rights. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak on this proposition? Deputy Wilson.
Thank you, sir. I'm pleased to follow Deputy Morell's position on the issue of rights. Listening to the debate, it's very clear to me that this is not about a process as to who completes a form or the choice as to who completes a form, but it's more fundamental than that. This is about establishing the basis in law to remove any discrimination around our taxation system, to remove the discrimination, and to make sure that we recognise the value and the contribution that women make in our economy and in our society. Studies of taxation have long taken gender discrimination and differences into account between married men and women. And there is a strong evidence base that suggests that married women experience adverse effects, as we've actually heard in terms of the testimonies that have been provided throughout this debate. I would ask the question, imagine if the discrimination and the inability to control one's own affairs, if those conditions were on the other foot. The proposals brought forward by the Treasury Minister are an attempt to create the conditions to remove these inequalities and to recognise women in their own right to be able to manage their own affairs without the need to rely on their husband. What women want is not particularly what men think women want. Women are economists in their home. They're the main earners in their home. They're the key decision makers in their home. And the reality is that women earn in their own right. Therefore, we as an Assembly should support the right of women to declare their income. And the sooner we move to this form of taxation, independent taxation, the better. These proposals are about modernising our tax system based on robust consultation, as Deputy Stevenson alluded to earlier on, a move towards a more equal society, and to recognise the obligations we have in CEDAW. This is about establishing a right, not a choice, and it's on that basis that I cannot support Deputy Farnham's proposal.
Thank you, Deputy. Does any member wish to speak on this proposition? I call upon Deputy Farnham to reply. Deputy Farnham.
Thank you, sir. And thank you to all who have spoken, sir. Another thought-provoking a debate, sir, with some very good speeches. And I'm sorry to say, sir, some, in my opinion, not so very good speeches as well, because regrettably, I think a strategy deployed here to defeat the proposition, so a proposition that was brought with the best, very best of intentions to make life easier for some of our islanders who really feel strongly about the tax system. And for the record, so I too absolutely believe in completely fair and equitable taxation, free of any discrimination for all people. I think that is should be beyond doubt, as I believe every member in this Assembly does. And I regret, sir, that it has been turned into a major gender issue. And I realise that some people feel passionately about this. I do too. But it's not really what my proposition is about. And I said at the beginning, sir, my proposition respects a previously agreed position of independent taxation as the default position for all new taxpayers and married couples and civil partners, sir. And this is to allow some further time for existing taxpaying married couples to adapt. So that's what it's about. I did, sir, vote for P78 in 2021, which was in relation to Phase 1, because I supported the principle. And as Deputy Mezek rightly said, this is not about principle, this is about the practicalities of representing or doing what we feel is in the best interests of some islanders. But I didn't vote, sir, for what is proposed to be being put for us, sir, which is, as I agree with Deputy Mezek, is a good fudge, sir. It's a good old Jersey fudge we have here. It's not a true independent system. It's a compensation scheme, I think, which is at the heart of the problem. So I did not vote for that. Incidentally, having a look back at the vote, so I noticed that the Chief Minister voted against P78 in 2021, and no doubt she had her reasons at the time, but she's on the right side of the argument, of the debate now. And I would like to remind members that my proposition seeks to achieve two key outcomes for Jersey taxpayers, sir. And I'll start by talking about CEDAW, sir, to further align ourselves with the international standards and recommendations set out in CEDAW. which is the Convention on the Elimination of All Forms of Discrimination Against Women, which was extended to Jersey in February 2021, as we know, to eliminate any form of discrimination against women that remain in our tax system, sir. And this can be achieved, sir. This can be achieved whilst retaining the ability for couples to file a joint return. And I'm going to stick with that terminology, sir, because I believe all members understand it. I think, sir, that the Chattels argument is beginning to wear a bit thin, of course. We look back on history and we learn from history, and we don't want to repeat it. And until recently, a married woman's income was always treated as the husband's income, sir. With hindsight, that was wrong. The filing of the annual return was the husband's duty. The tax liability was in the husband's name only, and a married woman, when trying to access tax information, would be not denied that access unless her husband provided permission. And these anachronisms have largely been confined to history. They should all be confined to history. But we can do that while maintaining the choice for islanders to elect to participate in a joint return or a joint assessment, sir, like many other countries who are also signatories to the CEDAW Convention do. Married man's taxation, as with Deputy Elvis, sir, I have, having been born in Jersey in 1964 and lived here for most of my life, never heard that expression before. Married man's taxation used in this instance. I couldn't find it anywhere on the Government of Jersey website, and it's certainly not mentioned in the Income Tax Jersey Law 1961, having word searched all 308 pages of that last night. It has been, I think, deployed, sir, in the reports and in the written speeches by officials for some ministers today. It has been deployed, I believe, to evoke passion, sir, and strong feelings, which it has succeeded in doing. Since the introduction of same-sex civil partnerships returns, this term, sir, married man's taxation, that I've never come across, sir, because it doesn't exist in the law, cannot be used for obvious reasons, because there may be no man on the return, sir, and no married couple. The terms spouse A and spouse B were introduced instead. In civil partnership, spouse A is initially the older spouse, but there is a 2-year window where the couple can elect to change this. This could also be applied, sir, to all joint returns. As of 2021, sir, both spouse A and spouse B have full and free access to their tax information and may elect for the independent taxation without the other spouse's permission. Where spouse B receives employment income, there is minimal room for coercion, sir, as Revenue Jersey regularly check an individual's declared income against income declared through the combined employer return. Where there is non-earned income, such as property or investment income, under the current joint return arrangement, responsibility is shared. In the case of a coercive relationship, there is no guarantee that the coercive spouse will not put undue pressure on what income the victim should declare on an independent return. For example, sir, under independent taxation, one spouse could be coerced into declaring property or investment income on their return, thereby reducing the tax liability of the perpetrator. I say this, sir, not lightly. I have been contacted by victims of coercion in marriages. And it's clear, sir, that whilst coercion can exist in very many forms, from the people I've spoken to, they did not think the tax return ranked very highly in their own experiences. Couples have the choice to open joint bank accounts, apply for joint mortgages, own property together, sir, to name but a few examples. These surely provide far more opportunity for economic abuse. Should we be stopping these? I don't know. Perhaps we should. Why should there not be a choice for those who wish to continue with joint returns? Why shouldn't there be a choice? So that is a question that the government have not answered. If some people feel outraged by the old-fashioned concept of a joint return, then they are quite free to choose independent assessments if they wish. Some key points and questions remain unanswered, sir, as we move to phase 2, which I think has provided quite significant flaws in what's coming towards us. Under the compensatory allowances system, an individual's tax affairs are still linked to the other spouses. Spouse A must know Spouse B's income in order to determine if the compensatory allowance is applicable and has been correctly applied. Who will take responsibility for reviewing Spouse A and Spouse B's tax returns? Will Spouse A still have to record Spouse B's income on their return, or will Revenue Jersey assess the independent returns together? Either way, sir, a joint return is necessary. How will errors in submissions impact the compensatory allowance? If Spouse B files incorrectly, that could lead to a tax liability for Spouse A. Could Spouse A then be liable for a late payment surcharge? The draft law tabled for debate on the 18th of July does not provide clarity on the practical application of independent taxations for couples eligible for the compensatory allowance. It is completely appropriate, therefore, that couples in this position retain the right to remain jointly taxed or file a joint return, sir, or whatever wording we choose to give it. Whether joint tax returns are discriminatory or not is subjective and depends on the context of the perspective from which the issues are analysed. Joint tax returns allow couples to file their taxes together, combining their incomes, deductions and credits. This option is available now, sir, to both opposite sex and same-sex married couples here and in many other countries. As I mentioned in my opening speech, sir, the primary purpose of joint tax returns is to simplify the tax filing process for couples and provide certain tax benefits. They are also more cost-effective for the tax authorities to process. Joint tax returns offer advantages such as lower taxes, increased deductions and eligibility of certain other benefits. So these benefits are designed to reflect the economic reality of couples sharing financial responsibilities, which for the vast majority of couples, sir, financial affairs are usually quite interlinked. Married, pensions, joint savings, joint investments, joint property ownership, generating rental income, sir, are just some examples. Having to fill in two forms and potentially a compensation claim is, I maintain, sir, unproductive and unnecessary. Ultimately, whether the joint tax returns are considered discriminatory, sir, depends on one's own perspective and the specific circumstances being evaluated, sir. And we have seen in this debate different people have very differing opinions on the matter, which largely represents their own conscience, their own views, and their own values, which is quite right, sir. I just want to refer briefly to the report tabled by the Minister to the proposition and just highlight some points, sir, that I hope members will find interesting. I'm quoting, sir. Consequently, Deputy Farnham's amendment to his proposition essentially asks the Minister for Treasury and Resources to introduce a modern form of joint taxation, so they accept that, for those married and resident before 2022 who choose not to move into independent taxation if the move is not mandatory. Despite claiming, sir, that the proposition tabled by myself, sir, wording agreed by the Gref and yourself or the bailiff, sir, despite them trying to have that sort of struck off earlier, but they have addressed it in their report. They go on to say this would introduce further complexity, and it is unlikely such modernisation could be achieved without significant overhaul of our revenue management system at considerable cost. So this is a revenue management system that was bought from a New Zealand company, so I think we're one of the few people in the world using it. It would be challenging to operate a system requiring joint signatures. In 2023, it's challenging to operate a system that would require joint signatures, particularly in an e-filing environment with digital IDs. And the Deputy's amendment does not seem to call for joint and several liability for tax debts. And this is a good point, and this is something I've spoken to Deputy Scott about, sir. I purposely didn't call for the Treasury to make, in this proposition, to include whether liability should be joint and several, as some countries do on joint returns, or a proportional liability, as some other countries do. So I left that open, hoping that if this proposition was successful, the government would deliberate on that matter and come back to this Assembly with the right choice there. I probably would favour proportional liability, sir. Maybe it could be a choice. It should be noticed that the last government did investigate the case for creating a modernised form of married couples taxation, but eventually ruled it out as impractical and unnecessary. Now, I was a member of the last government, sir, and I don't remember this coming to Council of Ministers or being discussed. I do not recall discussing the modernisation of married couples taxation. The government referred to it here, sir, as married couples taxation, which they said it wasn't earlier, but they used that phrase in their report. I could be wrong, sir, but I don't recall that. I don't recall anything coming to this Assembly asking whether we should modernise joint taxation. Instead, it was decided to introduce independent taxation for all islanders with compensatory measures, a position reflecting majority view in surveys and ultimately supported by this Assembly. I cannot accept, sir, that it is the majority view of tax-paying islanders that mandatory independent taxation is right. Deputy Farnham's proposal, of course, is superficially attractive, goes on to say. Superficially attractive when faced with a choice between mandatory or optional approaches. Well, that's a shame they've said that, because whilst that's a good point to score, I don't believe it is superficially attractive for the thousands and thousands of islanders who are going to be affected by this. They don't think it's superficially attractive. They are very concerned about it. Ultimately, it would mean Jersey would be running two separate tax regimes side by side for possibly another 60 years. Well, sir, as we heard earlier from Deputy Balash and others, there is a simple solution to this to provide more time, and that is a simple legislative amendment to Schedule 7 of the law, which would remove the date to provide some flexibility. I'm looking at Deputy Balash now, and hopefully he's going to be nodding in agreement if he can hear me. Yeah, I'll take that as a yes, sir. Yeah. The youngest married couple subject to would be able to apply to stay on this in their 20s. But we've been running side-by-side taxation, sir, since 1928. Now, I'm not saying what we did in 1928, of course it's not, but it can't be difficult to continue to do what we've been doing. Remember, this is not about the principle of independent taxation. It's about the practicalities of doing what is right for our islanders. It goes on, sir, to say, this would add complexity both for islanders, and importantly, sir, complexity for islanders and for our software providers and our revenue officers, rather than move closer towards simplicity. I'll just read that again, sir. This would add complexity for our software advisors and our revenue officers, rather than move towards simplicity. Are we running this island, sir? Are we running our tax regime in the interest of the taxpayer, sir? Or in the interest of our software providers, sir. Whilst we quite rightly have adopted CEDAW, the Convention of the Elimination of All Forms of Discrimination Against Women, sir, we've quite rightly adopted that and must continue to fulfil our responsibilities and obligations to that convention. We're also, sir, by the fact that we are here and alive, sir, we have also fully subscribed to the fundamental values of the Universal Declaration of Human Rights. This is a comprehensive statement of the rights and freedoms to which all individuals are entitled, regardless of their nationality, race, religion, gender, or any other status, sir. The freedom of choice is an important aspect of that. It's important because it is a fundamental aspect of the individual autonomy and human rights. It allows, sir, individuals to define their own paths in life, pursue their goals, and express their individuality. It refers to the ability of individuals to make decisions and act according to their own values, sir, not be coerced by others to follow their values, but to act in accordance with their own values, their own preferences, sir, and beliefs, without undue interference or coercion from others. If approved by the Assembly, mandatory independent taxation will be imposed upon all islanders from the year of assessment 2025. And whilst there is no financial impact for some, approximately 7,000 couples will see their tax liabilities increase. And this impacts mainly upon the lower income families and pensioners, with some higher income families seeing a reduced tax liability. There is a valid issue about the unsettling effect these changes will have on many couples, especially for the older generations. And similar concerns have been raised, sir, by the Citizen Advice Bureau and the Personal Tax Community Help Desk at events, which have taken place in parish halls and other locations across the island. So they are aware of it, sir. I'm just going to finish up, sir, with a few comments of islanders. We've all received many comments from islanders, sir. And I quote, "I feel very anxious that after 47 years of marriage, I may have to complete my own tax return. I cannot understand how this action would benefit anyone, so I would be interested to see if anyone could answer me in a language I can understand. I would certainly struggle with this if it were made law." As a married couple, we would very much prefer to keep a joint tax return as we have done for our whole married life. We feel that the proposed changes would be an unnecessary burden, could lead to errors, and certainly increase stress. It should be a choice. I strongly oppose joint taxation. We as a couple earn different wages. I'm professional, husband is not. So my tax would go up and his wouldn't change. I am Jersey, sir, as is my husband, and even for us, leaving the island is getting more attractive. Please fight to object to this latest nonsense and keep our right to make a choice, sir. And Deputy Howe, in her very good speech, quoted from another point. I'm just going to finish on the last paragraph, which I jotted down. I think that when this debate comes up in the States this week, you need for once to listen to the people of Jersey and understand their needs, not what you think is beneficial to your own beliefs, sir. With that in mind, let us listen to islanders on this one. Let us vote today not to compel, but to retain the freedom of choice, to allow existing tax-paying married couples and civil partners to retain the right to choose, sir. And let's give the government more time to take this away and and come back with something that is right and actually does present us with true individual taxation, sir, with no fudges. In the meantime, sir, all I ask is that we allow existing married taxpaying couples to continue to submit and file the joint return. Thank you.
Do you call for the appel?
I do, sir. Thank you.
And you ask for a vote on each paragraph separately, A, B, C and D.
I do, sir. Thank you.
Deputy Vinay?
Deputy Labby was asked if it could be recorded that she's unable to be here for the vote because she's at a funeral.
Thank you very much. Yes, so the greffier asked members to return to their seats and will be voting first on subparagraph A of the proposition. I ask the greffier to open the voting. All members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. I can announce that part A has been narrowly defeated, 20 votes pour and 21 votes contre. Yes. Both ways? Yes.
Those members voting pour, the Connétable, St Helier, St Lawrence, Trinity, St Clement, Grouville and St Saviour, and deputies Southern, Luce, Rob Ward, Alves, Farnham, Mesick, Balash, Coles, Porray, Catherine Curtis, Waltham, Rose Binet, Howe and Barbara Ward. And those members voting contre, the Connétable, St Peter, St Martin, St John and St Mary, and deputies Doublé, Morel, Lehegara, Ayer, Gorst, Moore, War, Miles, Scott, Renouf, Jearn, Miller, Ferry, Alex Curtis, Wilson, Stevenson and Andrews.
We now move on to part B. When the greffier indicates he is ready for me to do so, I'll ask him to open the voting. Voting on part B of the proposition. All members have the opportunity of casting their votes. I ask the greffier to close the voting. And part B has been adopted, 21 votes pour, 20 contre. Yes.
Those members voting pour, the Connétable, St Helier, St Lawrence, Trinity, St Clement, Grouville and St Saviour, and deputies Southern, Luce, Rob Ward, Alves, Farnham, Mesick, Balash, Coles, Porray, Scott, Catherine Curtis, Beltham, Rose Binet, Howe and Barbara Ward, and those members voting contre, the Connétable, St Peter, St Martin, St John and St Mary, and deputies Doublé, Morel, Lehegara, Ayer, Gorst, Moore, War, Miles, Renouf, Jearn, Miller, Ferry, Alex Curtis, Wilson, Stevenson and Andrews.
We now move to paragraph C of the proposition. And when the greffier indicates he is ready, which he is, I open the voting and invite members to cast their votes on paragraph C of the proposition. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that paragraph C has been rejected, 20 votes for, 21 votes contra. Do you want the names again?
Those members voting for the Connaught Arbor, St Helier, St Lawrence, Trinity, St Clement, Grouville and St Saviour, and Deputy Southern, Luce, Robord, Alves, Farnham, Mesick, Coles, Borey, Scott, Catherine Curtis, Feltham, Rose Binet, Howell and Barbara Ward. And the members voting contre, the Connaught Arbor, St Peter, St Martin, St John and St Mary, and Deputies Doublé, Morel, Lahigara, Ayer, Gorst, Moore, Balash, War, Miles, Renouf, Jearn, Miller, Ferry, Alex Curtis, Wilson, Stevenson and Andrews.
Now move to part D of the proposition. And once the graphier is ready, which
So,
he is.
sorry, I would be grateful if you would consider the impact of paragraph B being adopted and paragraph A not, as they do slightly conflict when paragraph B refers to any such married couples.
I don't think that during the vote is a time to make any observations with respect. D, if the graphier is ready, we open the voting on D, the last paragraph of the proposition. All members with the opportunity of casting their votes. I ask the greffier to close the voting, and paragraph D has been rejected. 18 votes for, 23 votes contra. Yes.
Those members voting for the Connaught Arbor, St Helier, Trinity, St Clement, Grouville and St Saviour, and Deputies Southern, Luce, Robord, Alves, Farnham, Mesick, Coles, Porray, Scott, Catherine Curtis, Feltham, Howe and Barbara Ward, and those members voting contre, the Connaught Arbor, St Lawrence, St Peter, St Martin, St John and St Mary, and Deputies Doublé, Morel, Lahigara, Ayer, Gorst, Moore, Balash, War, Miles, Renouf, Rose Binet, Jearn, Miller, Ferry, Alex Curtis, Wilson, Stevenson and Andrews.
Sir?
Yes.
Two things. One, just relating to that vote. So democracy is an amazing thing in action. I think it's fair to say, sir, that if Part B is the one that's been accepted, we will need to consult with your chambers and the greffier. We've already undertaken to consult with members to really understand fully how that vote interacts with the other paragraphs which have been rejected. It seems to me that it can't properly interact with them. But I think, so rather than us trying to deal with that now on the floor of the Assembly, we should liaise with your,
I don't think
office.
it's probably me to comment on the outcome of any decision made by the Assembly, although you will remember that at the outset, Deputy Balash asked for a separate vote because he indicated he was opposed to C, and members have cast their votes in accordance with their wishes, but I don't think I should say.
But so I think the consideration was from certainly quite clear to most members of the Assembly that Part B should have fallen away following the vote on Part A.
Well, there were 4 separate votes asked for, and that was what was promised at the outset, and that's what what occurred. B was adopted. Yes, Debbie Scott.
I just want to say, as somebody who did vote against A and voted in favour of B, I'm very happy to offer my interpretation anytime anybody wants it. Thank you.
Well, you may find lots of people beating to your door. Yes, Deputy Ward.
So this is a slightly different issue. I'd like to raise that I believe that yesterday, during oral questions, the Assistant Minister may have accidentally, and I'm sure it's accidentally, misled the Assembly with a figure that was given an email that we've all received about the attrition rate amongst teaching staff. Now, the reason I raise this, sir, is that yesterday that was in the public domain and publicly stated. The email has only gone to States members. Now, I wouldn't expect the Minister to answer now because I don't think that's fair on the hoof, but I wonder if after lunch we'd just get a short answer that corrects that publicly and puts that into the public domain, given the importance of democracy, as we've spoken about before, and transparency as this government portrays and we all agree with. Thank you, sir.
Thank you. I'm sure that's been heard by this.
Sir, I probably can answer.
If you wish to.
Yes, what, if I can know what the figure is that was incorrectly stated?
So it's the one the Minister stated himself. If he looks back through his
There
speech.
shouldn't be a debate on the floor of the Assembly.
Okay, I assume it must be the attrition rate. It's the attrition rate, because there were a number of figures stated. The attrition rate given yesterday was for the 12 months to date. The figures in the letter that has been sent out is the attrition rate for the year 2022, and therefore I stand by what I said in the Assembly yesterday.
Very much. We now move to the next.
Sorry, sir, if I may, sorry, I want to labour the point here, but that figure that was given yesterday does not reflect the true attrition rate in a yearly mechanism. And I think there does need to be a qualification of the answer, because it really, I think it is misleading for the Assembly and the public to have one figure and then be sent completely different figures over the last 5 years, all of which are, some of which are more than double the figure given. If we're actually going to have a genuine set of answers from all the questions in this Assembly.
Sir, can I just respond? Because I did make it quite clear yesterday.
I don't think this is the appropriate proceeding. You stand by what you said yesterday, and that's the end of it.
So, yesterday, we, by entirely my error, so you were trying to correct me, that we should have taken P29 addendum, the Act Operatoire, to give effect to the changes to the 21E regime, and I wonder if we could take it now as the next item. So, and I offer my apologies to you and the Assembly.
Yes. I invite the greffier to read the citation.
Draft Act declaring that the Income Tax High Value Residence Amendment Jersey Law 2000 has immediate effect. The States make this Act under Article 12 of the Public Finances Jersey Law 2019.
Yes, Minister.
Thank you, sir. It is as I've just described, and I propose the Act. Thank you.
Well, perhaps you want to explain to members why it was what you said yesterday about Article 3 of the law having the effect that you contended incorrect. It may assist members to understand that.
More than happy to congratulate myself further, sir. So the law as approved yesterday by members, rather than being regulation, is an amendment to primary law. Members will be aware in the normal course of affairs, primary law must go to His Majesty in Council for sanction. What the Act Operatoire does is allow for this Assembly on matters of taxation to bring them into immediate effect. And in this instance, we voted yesterday for immediate effect to be the 14th of July, but it still requires the Act Operatoire rather than that primary law amendment needing to go to His Majesty. Thank you.
Thank you, Minister. Does any member shall speak on this proposition? Thank you very much. Are members content to adopt this on a standing vote? If so, those in favour, please kindly show. Thank you very much. The Act has been adopted. The next item is the Jersey Police Complaints Authority, the appointment of member, lodged by the Minister of Home Affairs. The main respondent is the Chair of the Children, Education and Home Affairs Scrutiny Panel. And I ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion, in accordance with Article 2 of and the Schedule 2, the Police Complaints and Discipline Jersey Law 1999, to appoint the following person as a member of the Jersey Police Complaints Authority for a period of 3 years, commencing immediately. Mrs. Rachel Catchpole.
Yes, Minister.
Thank you, sir. I'm very pleased to recommend that the Assembly reappoints Mrs. Rachel Catchpole as a member of the Jersey Police Complaints Authority for a third and final 3-year term. Mrs Catchpole has been a valued member of the authority since 2017 and was reappointed in 2019 for her second term. She has served as the Deputy Chair for some time, and I'm delighted that she has indicated a wish to continue to serve in that important role. As members will be aware, the Jersey Police Complaints Authority supervises the investigation of complaints against the States of Jersey Police. This independent oversight is crucial to maintaining and building trust and confidence in our police force. The authority is constituted under the Police Complaints and Discipline Jersey Law 1999, and in accordance with that law must consist of a chair, as well as not less than 6 and no greater than 8 members. I'm sure that the Assembly will join me in paying tribute to all members of the authority who all serve on a voluntary basis and give up their time to serve on the authority for no remuneration. Sir, I'm pleased to recommend the appointments to the Assembly, and I make the proposition.
Thank you. Is the proposition seconded?
Yes, sir.
Does any wish to speak on the proposition? Yes. Deputy Catherine Curtis.
Thank you, sir. I just want to say that the scrutiny panel supports this appointment, and I recommend to States members that they read the Jersey Police Complaints Authority report. Thank you.
Thank you, Deputy. Does any other member wish to speak on the proposition? Deputy Rob Ward.
So it's just to check something. If, as a member of the Jersey Police Authority, there's no conflict in me voting on this, and the same for Deputy Farnham. I'm just unsure.
I don't believe so, no.
Okay, great.
Does any other member wish to speak on this proposition? No, I call upon the Minister to reply.
Thank you, sir, and I thank the Chair of the Home Affairs Scrutiny Panel for her comments, and I maintain the proposition and call for the appel.
The appel has been called for. I invite members to return to their seats. And I invite the greffier to open the voting. All members have the chance to cast their votes. I ask the greffier to close the voting. I can announce the proposition has been adopted unanimously, 38 votes for. The next item is taxation of high-value residents, lodged by Deputy Feltham. And the main respondent is the Minister for Treasury and Resources. I ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion: A, to request the Minister for Treasury and Resources to bring forward the necessary legislative changes to the Income Tax Jersey Law 1961 to remove the prescribed limit relating to high-value residents' income tax contribution. B, to request the Chief Minister to suspend the high-value residence scheme in 2023 until the legislative changes detailed in A are implemented. And C, to request the Council of Ministers to undertake a full and comprehensive cost-benefit review of the high-value residence scheme to be presented as a report to the Assembly by the 1st of November 2023.
Deputy Feltham.
Thank you, sir. And before I begin, I'd like to express my solidarity with the teachers that are out in the Royal Square today. I think it's an interesting juxtaposition talking now about high-value residents. I brought this proposition forward having read the report that accompanied P29 and having felt the frustration that I think I sensed many other members may have felt during the debate on that proposition yesterday. P29 appeared to me to make a flawed position better than it currently is, but certainly fell far short of where I feel the policy needs to be. Further, the review of the 21E regime that was promised by the government last year doesn't appear to have been completed comprehensively or to the quality that many of us may have been expecting, and to which would have given us comfort that the regime is meeting the broader needs of the community. Part A of this proposition is asking the Assembly to sign up to the principle of fairness and equity, and to give a clear direction that individuals gaining residence under the 21E scheme should be treated in the same way as all other taxpayers. Approval of this part would see the removal of the current policy of giving a preferential rate of 1%, yes, that's 1%, on income of over 1.25 million to these people. I'll repeat that again. A preferential tax rate of just 1% on income over 1.25 million. If that is not a regressive tax, I don't know what is. It is important also to note that this rate is not available to any other taxpayer. Should Part A be approved, then Part B asks for the scheme to be halted until the requested changes have been made. This will ensure that the principle of fairness would apply to any new people acquiring 21E status. Part C asks ministers to assess the benefits and costs of the scheme to the island, which will provide assurance that it continues to operate in the best interests of our community, and to present this review as a report to the Assembly by the 1st of November this year. In short, the key issues this proposition seeks to resolve are that the current policy supports an unfair tax system which treats those with 21E status more favourably than all other residents, and that the government has not issued any report or recommendations which consider the 21E regime in light of current high employment and a workforce shortage, the housing crisis and the rising cost of living. Having read the Chief Minister's comments paper, I find it very disappointing that the comments have completely neglected to address these issues and explain the government's position in relation to them. It fails to explain how the scheme meets the challenges around inflation, social inclusion and our ageing demographic, and also fails to supply any evidence to support the government's claim that its proposals were carefully developed or well thought through. Instead of providing a well-considered response to my proposition, it appears that the Chief Minister has instead doubled down on the rhetoric and failed to provide any evidence to support her position. Indeed, the statistical information provided is light, and there has been no analysis undertaken on the impacts of this scheme on housing, the labour market, social inequality, or the broader economy. In fact, the comments contain no analysis at all, or any evidence that ministers gave these issues thought when agreeing their policy. I do hope that ministers heard some of the concerns voiced by members yesterday during the debate on P29, and I hope they understand that during this debate, just repeating rhetoric won't wash. As was mentioned yesterday by some members, the public do regularly question the value of this scheme and also the inequity of it. So I have a request of ministers, and I would like them to address these concerns directly during this debate. Firstly, housing. I would like to hear from the Housing Minister about what evidence he has about whether or not the current scheme has an effect on housing affordability and availability. And given the answer to written question 302/2023, which confirms that 21Es do not need to spend any time in residence on island, I would like to know how this policy sits in relation to his empty homes plan. Secondly, planning and environment. Given the Chief Minister's report states that people with 21E status have purchased a total of 264 properties, with a total value of over £1 billion, and in consideration that these properties are likely to be much larger than your average family home and comprise of surrounding land, could the Minister for Environment address whether there has been any assessment undertaken on the effect of this scheme on the potential availability of land that could be used for affordable housing, public open space, or even the provision of active travel corridors? Then we have the inequality when it comes to applying the Control of Housing and Works law to 21Es compared to all other categories of residential qualification, including those that apply to Jersey-born people. Could the Assistant Chief Minister with responsibility for population policy please explain whether she thinks it is right that the people with 2-1E status seemingly have an irrevocable entitled status from day one of taking up residence. And I think, as we have heard, in this case, the term residence is very loose, when all the rest of us have to live here for 10 years before achieving entitlement, and also have restrictions imposed on absences from the island. The Chief Minister's comments also make much of maintaining and protecting the island's reputation. And it's a shame the Minister for External Relations isn't here. Perhaps his Assistant Minister could explain how approving a tax-efficient residential status to a Russian oligarch goes down on the world stage, and what his international counterparts think of us giving tax preferential residential status to people who don't have to live here and seemingly never have to set foot on the island. Given the government's continued assertion about the positive economic impact of the island, I was surprised that the comments paper didn't contain any data to support this. I think the burden of proof here falls to the Minister for Economic Development, and perhaps he could inform the Assembly during this debate what economic impact assessments have been undertaken on the scheme and the results of those. The comments paper also makes claim that I am calling for a significant change to the tax system. I'd like to ask the Minister for Treasury and Resources to explain why this is considered to be such a significant change when it will affect such a small group of people. I would also like him to confirm that it will not impact on the tax take from people who already hold 2-1E status, and therefore does not put at risk the level of income being achieved currently through individuals that already have this status. Further, we know that the Minister stands by his principles that taxes should be low, broad, simple and fair. So perhaps he could explain why he wishes to maintain the prescribed limit relating to 2-1Es and how he considers it to be fair. The Chief Minister's comments conclude that we should be positively welcoming and supportive of new migrants who move to Jersey wishing to become part of our community, including those who are wealthy. I ask the Assembly, should we not be equally welcoming of all new migrants who are part of our community and treat everyone equitably, regardless of wealth? Sir, I make this proposition.
Thank you, Deputy. Is the proposition seconded?
Yes, sir, with pleasure.
Does any member speak on the proposition? Deputy Ward.
So I was actually going to just seeing that ministers are only arriving back and there's a few minutes to propose that we have the adjournment and carry on this debate after lunch because I'm pretty sure a number of members would want to speak. And seeing as we've got about 5 or 6 minutes, I wouldn't want to speak and then be ended and come back because I've learnt before that breaking your speech in the middle is not a good thing to do. So I wonder if I could propose the adjournment, please, sir.
Is that seconded? Yes, sir. Are members content to adjourn now? State stands adjourned until 2:15.